I'm doing that. Can't hear you.
You? No.
Yeah. It's fun. It's good times.
On what platform are you virtually trolling?
On the hackathon.
Directly in the hackathon? Gotcha.
Yeah, you got like a little 3D avatar where you can run around during the getting people to talk smack.
Yeah, how do you set up your 3D avatar? I gotta go do that.
I just clicked the link to go into the virtual deal, and it automatically prompted me
VR
to set
Expo?
my avatar.
Oh,
I can't have a cowboy hat though, so I'm kind of disappointed in that.
Oh man.
Yeah.
There's no cowboy hat? All right. Well, platform upgrade for next year. I think that's pretty clear.
You bet.
No, make it a hack item for this hackathon that they've got to add some cowboy hats.
Right. By the end of the hackathon, Tyler needs to be a very tall man with a white hat.
We're live. We're live.
And we're live. Are we live yet?
We've been live for a minute or two. Yeah.
Mr. Chairman, we actually just went live just a few seconds ago.
Excellent. Well, welcome back. Hope everyone enjoyed your lunch. The second half of the first day of the Select Committee on Blockchain, Financial Technology, and Digital Innovation Technology, or the Blockchain Select Committee. We have a few topics this afternoon to get through, and the first one that's going to kick it all off, let's see, where's Mr. Co-Chairman? Mr. Co-Chairman's not here yet, is he? Let's see if he's on the list. I see Co-Chairman Olson, but I don't physically see him. So let's hold off for a couple of minutes before we pick back up on uniform electronic wills. While we've got a little bit of a pause, Caitlin or Representative Lindholm, any updates from the hackathon? What's going on? What would you like to share with folks that might be tuning in?
I think you can, for the folks that are tuning in, if we as a committee get to the point of boring you, there is always the opportunity to join the virtual hackathon. Registration's free, where you can tour around and you can learn about some of the different companies that are in the state of Wyoming, and some of the different companies that have come to the hackathon to be represented. So there's that. And then also at 1:30, they're going to be doing the, what is that called? The parade of the...
Have to look at the runner show here.
Yeah.
Because we've got multiple events going on at the same time, as you know, which is very cool.
Here we go. I think I got the schedule. Okay, so at 1:30, the March of the Stampede startups will happen. And so that's all of our competitors in the startup challenge that will be, I don't know how much they're going to talk about their projects or anything like that. I think maybe it's just an introduction. I think
so. Just an introduction. Yep.
Aren't you the chairman of this organization?
I am.
Yeah.
Feels like you should know more about this.
Yeah. Uh-oh. Yeah. I'm getting ribbing for not having worked hard enough on this.
Seems a little blame shifty there.
Oh, good point.
Yeah, I think he's just trying to dodge there. All right, while we're waiting for Co-Chairman Olson to walk us through electronic wills, I think it's potentially important that we take a look at the avatar builder.
I'm working on mine. Yeah.
Blockchain task force. So this is the starting point for me. And,
Mr. Chairman, you should probably change your name.
You don't think Victorious Hayes Guest is sufficient? All right.
No, that's probably not a good idea.
All right. So you got that. Do we have Jared yet? Not yet. All right. Where's my blonde hair? Somewhere-ish, blondish.
You can't even get cowboy boots.
I know. I'm noticing that. Not a cowboy.
I'm going to blame Rich Kopko, and I think.
Yeah, we'll go with that. Blonde Casablanca. Is that me? Does that look like me? That looks like me. And that definitely is me. Obviously,
bald on the front end.
It looks like your kid.
Yeah, that'll have to do. He's better looking than I am. No, yep. There's no cowboy hat here. Are there cowboy boots?
Nope.
No.
I see antique Italian leather. Okay. What are my face options? All right, where's one with an unfortunately large nose is what I'm looking for. Probably that guy, maybe. I don't know. Yeah, we'll go midstream. All right. There's Co-Chairman Olson. Co-Chairman Olson.
Hey, sorry for my rude intrusion into whatever is happening here right now.
No, what was happening actually was we were killing time while we were waiting for you to talk to us about electronic wills. So I built my avatar in WIO Hackathon space. I'm going to stop my screen share.
Mr. Co-Chairman, just to excuse my tardiness, I was hosting a president candidate in my office, and he's quite the talker. So we can chat about that later.
That will happen from time to time. Excellent. All right. Well, Mr. Co-Chairman, then we are back. We are streaming live. We just did a little update on the WIO Hackathon, and it brings us to our 1 o'clock agenda item on uniform electronic wills. I know we've got some discussion here, and we've got a bill draft that we took a look at last time, if I'm not mistaken. So with that, the floor is yours, Mr. Co-Chairman. Take us through the wills.
Sure. So give me 1 second here to get my binder open.
No worries. Do you want me to go rebuild my avatar?
Thank you. All right. So Uniform Electronic Wills Act. We actually, where we left off is honestly where we begin. You were provided a bill draft, which is a uniform bill from the Uniform Law Commission in, it's one of our first meetings, I believe. That bill remains the same. It's we can walk through it. Of course, we'll bring in LSO to walk through it. I think that's probably a good idea. But I'll turn it over to David to do that in a moment. But to give you just some background on where we're at with this concept is being circulated throughout our bar. I know we heard a little bit of testimony, but really nothing substantively from the trust and estates section of the bar. I was hoping for something a little more substantively. We didn't really get that. I know that the Wyoming Trust Association also circulated this legislation through their members in their quarterly meeting, which was held on Tuesday. Looking back at their minutes, I don't really see much of a discussion there either. So I was hoping that today we would have some public comment, Mr. Chairman, from some members of our bar. I think that's what's really lacking, and we may just have to formally begin to move the bill forward in order to get that, so that we have something substantively to talk about. So what I want to do is, because it's been a couple of meetings in between, I would like to bring David in so we could walk through this, and we don't have to go line by line, David, but remind us what we have here in front of us. In particular, the co-chairman, I, and David have fleshed out a few areas inside of this legislation where we could bring some modification to the Uniform Act. So highlight those and touch on those for us. But in essence, again, just to remind the committee a little bit of background here and foreshadowing, at least in my mind, where we're headed. And I spoke about this at a conference over a year ago in the concept of blockchain wills, which is really where I'd like to see Wyoming end, is something much more than just an electronic version of a will. And I think that that's a progressive process for Wyoming, particularly as I begin to have this conversation with the bar and whether we can have a will in electronic form, then alone a truly digital will, are very different conversations. And I think that this is a good intermediate step to get us into that world. The bill also came right during the beginning stages of the COVID pandemic, and possibly posing a solution to a lot of access issues that folks have. So we can discuss that as well. But David, if you would walk us through the legislation, please, then we'll take it from there.
Go ahead, David.
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office. to walk through 21 LSO 29 working draft 0.6, the Uniform Electronic Wills Act. The first thing you'll see with this bill draft is just a staff comment, which includes some language that was not included in the bill draft. But if the committee decides that it should be, we can certainly put that in. On page 3, we jump into kind of the core of the bill. It creates 4 new sections added on to the general section of the wills statute. And the first thing here we get is the execution of electronic will, which kind of outlines what that is. And it defines that an electronic will is a record that is readable as text at the time of signing, that it's signed by the testator or another individual in the testator's name in his physical presence and by his direction, and that it's signed in the physical or remote presence of the testator by at least 2 competent witnesses within a reasonable time after witnessing, that the signing of the will, after witnessing either the signing of the will or the testator's acknowledgement. So that kind of provides what the electronic will is. On page 4, subsection B, we see kind of what could be considered a significant change there. The intent of the testator, that the record under the earlier paragraph of this section be the testator's electronic will may be established by extrinsic evidence. In other words, the intent could be established by extrinsic evidence to show that it was an electronic will. The next section, 6.2.126, or excuse me, 2.6.126, which kind of starts at the top of page 5, simply provides that an electronic will is a will for all purposes of the law of this state. Moving on, 2.6.127 provides that if a will isn't in compliance with that electronic will statute, it would still be considered to be in compliance if it's in compliance with the jurisdiction where the testator is physically located when he signs the will, or where he's domiciled or resides when the will is signed, or when the testator dies. On page 6, section 2.6.128 provides for the revocation of an electronic will, and provides that an electronic will may revoke all or part of a previous will. That subparagraph B there provides that how that revocation works, that a subsequent will revokes all or part of an electronic will expressly or by inconsistency, or some physical act that we see in paragraph 2, that a physical act, if it is established by a preponderance of the evidence that the testator acted with the intent to revoke all or part of the will. Section 2.6.129 provides that an individual could create a certified paper copy of an electronic will by affirming under penalty of perjury that it is an accurate copy of the electronic will. On page 7, we get into some amendments of existing statutes, providing new definitions to conform Wyoming law with the Uniform Electronic Wills Act, and provide some of those definitions to make it applicable. The first new definition we'll see there is a definition for electronic on line 14, which means relating to technology, having electrical, digital, magnetic, wireless, optical, electromagnetic, or similar capabilities. We provide a definition of remote presence. That means that the relationship of 2 or more individuals in different locations communicating to the same extent as they would if they were in person. And on page 8, we get a definition for electronic will, which we've seen previously at record, and a definition for sign. At the bottom of page 8, we see an amendment to the requirement that a will be in writing, just providing that if there's something different in the electronic will statute, that would take precedent, or that it applies. On page 9, an amendment to the self-proving wills, simply allowing for electronic wills, and a new paragraph there, or subsection. A signature physically or electronically affixed to an affidavit that is affixed to or logically associated with an electronic will under this chapter is deemed a signature of the electronic will. On page 10, section 3, this act would apply to the will of a decedent who dies on or after July 1st, 2021, and the effective date of the act is July 1st, 2021. With that, I would answer any questions on this.
Thank you, David. And just hold on, Representative Greer, I got you there. I just want to back up to the non-lawyers on the committee. I think, as you pointed out, the meat of this legislation really is 2-6-125. And that's pages 3 through 4, because that tells us really what, electronic will, I think that's pretty simple. We're just talking about something that's not in paper form. I think everyone can follow what that means. I think it's the execution of the electronic will that is the significance of the bill, David. And I just want to walk through those elements and compare them to existing traditional wills and see where the difference is. So under 2-6-125, we have, right now we're talking about something that just exists electronically. Otherwise, it's the same as it is on paper. But here's where it maybe slightly changes our process in Wyoming. So step 1, it is a record that is readable as text at the time of signing under paragraph 2 of this section. So that's what we just talked about. So it's readable as text. It is signed by the testator, which is the maker, the person who's making it. So no change there. Everything's still the same. Or another individual in the testator's name. So in the maker's name, in the testator's physical presence, and by the testator's direction. Let's circle back to that, because that, for those non-lawyers on the committee, that's probably the biggest departure from our traditional wills, although not unusual, but we'll circle back to it. 3, signed in the physical or remote presence of the testator by at least 2 competent witnesses with a reasonable time after witnessing. So here's a departure, David. It's signed in the physical or remote presence. So right now, arguably, the law requires it to be in the physical presence. I think the courts have really honed in on that, and we talked a little bit about that when we first introduced this bill. Anyone who's ever gone through this process knows that when they're signing a will, they have in the room with them 2 disinterested witnesses and a notary. Those witnesses can't be hiding behind a wall or behind a curtain in a hospital, for example. They must actually be in the physical presence. So this is the crux of the legislation, is that they can now be remote. Okay, so that's a big departure. The signing of the will under the paragraph of this section, or the testator's acknowledgement of the signing of the will under paragraph 3 of this section, or acknowledgement of the will. And then the last part, the intent of the testator that the record under paragraph A1 of this section be the testator's electronic will can be established by extrinsic evidence. I'm sure that one's going to give, I think the heartburn that exists here is probably going to exist in that paragraph. And in the paragraph about handing this off to an individual. So let's go back to the handing it off to an individual. For the non-lawyers in the room, you can do that through a special power of attorney. You could give away your power to make or change wills. This is probably, though, very substantively different from that, because it's declaring in statute that you can, that it can just happen under another individual's act of signing. I will say that provision doesn't have to exist for this bill to do what it's supposed to do. If anyone has heartburn about that, we can talk about that provision. I would be game for for removing it. It's unnecessary. Because what's necessary is really on page 4, lines 4 through 7, I think, is where the problem we're trying to solve. It's simply just being able to execute this thing remotely. Although if you were to take out the provision that another individual could execute your will on your behalf, you could still do that. It's just not statutorily automatic. You could still, again, through a power of attorney, provide someone a special authority to do that. I'll note that when we passed the Uniform Power of Attorney Act, I was a co-sponsor to that, Senator Nethercott was as well. One of the hot powers that we specifically reserve to an individual is just that, the ability to change wills. It's not automatically given away unless you specifically designate it away. I noted that because I saw Senator Nethercott question what I was just saying, and she's right. Most lawyers aren't gonna tell you to give away your testamentary ability to amend your own will, and nor should they. That's why we call it a hot power, and in very rare circumstances would you do that, which is why I actually have heartburn with this provision myself. Why I'm spending so much time talking about it is I don't think that it's necessary for the bill to do what it's doing. The last part that's probably confusing to me, and we'll have a discussion about it, is on page 4, lines 16 through 18. That's the extrinsic evidence establishment of the intent of the testator. I suppose the idea behind it is that we want some testimony we may want some testimony in a probate court that the testator intended to actually create his will, especially if somebody else is signing it on his behalf. So I don't know, David, if you could speak more specifically to those two provisions in terms of we have other states that have enacted the Uniform Act. Have they enacted it verbatim? Is there any departure there? And in your opinion, how would it, removing either one of those, would we still accomplish what we want to accomplish? Is it necessary to have the intent of a testator? Is it necessary to even have that provision about the intestator's intent? What do you know about it, David?
Mr. Chairman.
Go ahead.
Oh, thank you. As of, and I haven't checked, but as of July 16th, no state has actually adopted the Uniform Electronic Wills Act. But there were about 10 to 15 planning on introducing bill drafts in their next sessions in 2021. I haven't looked at any of those particular drafts, so I'm not sure how well they conform with the Uniform Electronic Wills Act. With respect to the question of the intent of the testator and the extrinsic evidence, if you'll give me just one moment, there is, my recollections, there's some commentary on that in the Uniform Electronic Will. I'm just flipping through, trying to find that for you quickly here. But they did have some reason for that change. And I guess I would ask if you come back to me in about 3 minutes, I have a good answer.
3 minutes. You've got exactly 3 minutes, Mr. Hopkinson. And with those 3 minutes, I expect to hear interesting things from Senator Nethercott. Go ahead, Senator.
Thank you, Mr. Chairman. Kind of my thoughts on the topic overall is that in light of the recency of the uniform laws production of this particular bill draft, which I think was in 19, so last year, and the lack of any states moving it forward, and I don't, it would be my position to not move this forward now as a result of the need to kind of get some of those concerns that are in the Uniform Commission's bill draft remedied, the one most concerning is the one that we're talking about here, and I'm buying you some time, Mr. Hopkinson, and to the other lawyers on the committee, of course, when you have someone else sign for you, that kind of, circumscribes the entire purpose of a will, which is, and the need to have separate witnesses and a notary in order to understand and confirm that you have testamentary capacity, which is far different than contractual capacity. And so we are familiar with, and this kind of originates out of signing electronic documents all the time, right? I can buy a house, I can grant someone else the power of attorney to bind me to millions of dollars worth of financial commitments, right? A power of attorney can actually do that. So what's the difference between that and giving all my stuff away upon my death? Well, actually pretty significant. And it has to do with the difference between testamentary capacity versus contractual capacity, which is a fundamental concept in probate law and trusted estate planning and contract law. And so by essentially removing that concept in this bill draft from our understanding of that in the laws of inheritance, essentially, that's a pretty fundamental change. And I do think it's notable that the lack of participation from those members of the bar, and I understand and believe that Co-Chairman Olson has reached out to them with no real response, but I have a feeling it's as a result of their inability to kind of cogently respond without a great deal of heartburn, and their maybe lack of familiarity with the legislative process, particularly this committee. And so those are kind of my thoughts right now. I think we continue to keep this on the radar. I do think that ultimately the future of wills and estate documents will look different as a result of our digital world, but I don't know that the time is now.
Thank you, Senator. Back to you, Mr. Co-Chairman, then Representative Greer.
Yeah, and I'll invite, thank you, Mr. Chairman, obviously more discussion, but I definitely actually agree with Senator Nethercott, and this is my idea. And I've been desperately trying to pull in my bar to have this conversation with me. And, we just haven't had a real substantive conversation. And I wonder, I'd like to hear from Representative Greer, but also I'd just like to throw it out there. I wonder if maybe Senator Nethercott, you said that no state has adopted this, and there's some issues with the uniform law. And then it was the last part that confused me, which was that wait until the Uniform Commission works out those issues. I mean, we're the Wyoming legislature. So what I would, if the idea is bad, and the idea of having remote signed wills is bad, then let's come out and say that. But if the idea is worthy, and the vehicle, this isn't the vehicle, and I will agree that it may not be, then let's find the vehicle that gets us there. And maybe right now, through this committee, that's not going to happen. Maybe we should ship this over to judiciary, and it should become more of a next year's interim topic, whatever it is. But the one thing I want to figure out is if the idea of having remote and digital wills is a good idea, then let's figure out how to do it. If it's a bad idea, let's just come out and say it's a bad idea. I don't think this vehicle is perfect either. I agree with Senator Nethercott on that. So thank you.
Thank you, Mr. Co-Chairman. Let's go to Representative Greer and then Senator Dockstader.
Thank you, Mr. Chairman. This is a good idea, but it needs a lot of work. And let me just make some points. One, I appreciate the bill draft, so I have something to look at, ponder, and compare with the current statutes. But let me point out, this is somewhat workable. And let me first start by saying, for like 5 years or so, it's been over that, I've worked with I will call our estate planning bar in bringing legislation to enhance our probate code, our trust code, other vehicles that's slowly moved Wyoming up Forbes' list to be a top tier state with respect to estate planning and financial planning. And that's part of our diversification of our economy, something I think is very appropriate for this committee in this particular issue. So the overriding concern, though, with this is how does it mesh with the existing statute? I mean, this is presented to us almost as a notwithstanding, if you have an electronic will, then these are the rules, because they fly in the face of how we execute a regular will, the old-fashioned way. Okay, that's fine. That's what we're trying to do. However, there are years and years of case law, and there are definitions that are carried in Chapter 6 of Title II that are necessary in order to interpret these. And if you want to talk about something contentious, talk about my great-grandfather's old saddle in a probate. That's where stuff gets heated. That's where people spend hundreds of thousands of dollars in litigation. So for example, the concept of the remote witnesses are fine, but again, we use the term competent witness. And so when you look at 26112, a competent witness is a witness who does not receive anything under the will unless they would otherwise receive under the intestacy statutes. So we're going to use that term, a competent witness in this section. It needs to be beefed up and have that same meaning behind it. Another component of this is we have a provision in our statutes that deal with what happens upon an annulment or what happens upon a divorce and how that affects your will. And so we would remain silent if this was a notwithstanding. Being signed by another is not particularly an issue, but it would be good to give guidance on how that occurred. And I have been present where we've done estate planning with someone that was not physically able to sign a document, and we dealt with that. And those are things that we need to be thinking about as we do this. The intrinsic evidence component on page 4 gives me a great deal of concern. I don't think you can just have a memo. I mean, I think that document needs to demonstrate your intent that this be your last will and testament. So those are just a list of these. The other one too, that was on my list regarding the choice of law, and I have to scroll through what page that is, but we do have an existing statute that the meaning and the legal effect disposition of a will is determined by the law of the state in which the will is executed, unless the will specifically says otherwise. So my point in bringing up these 4 or 5 items is that this is something we could do. I think it's something we ought to look at doing. However, we have to put a lot more thought in it, and there are a lot more layers to that to have it mesh with the understanding and the disposition of wills, the probate of wills in the future, and that we don't leave a wide gaping hole in our law that's going to do nothing but cause litigation. So like the idea quite a bit, actually. But I agree, we need a lot more work on it. Can we do it this year? I don't know. That's up to the chairman to figure that one out. So those are my comments.
Thank you, Representative Greer. Senator Nethercott.
Thank you, Mr. Chairman. Yeah, so, the co-chairman asked, you either like it or you don't. It's not a matter of like, it's a matter of a reality that's where the world is going digital, as I indicated before. So we will have digital wills in the future, but the legal nuances associated with some of the challenges that faces, I believe it's best to have worked out later. I don't think having the ability to make a digital will moves Wyoming up or down on Forbes' list for economic diversification concepts, because most people aren't doing their wills in Wyoming. They're locating their statutory trusts here, certainly, but I don't know that they're drafting their wills or that's their primary estate vehicle plan is a will. That said, there's a lot to work through, and I do think that the topic is maybe more appropriate in a different committee to work on as a full interim. Just because the document is electronic, I don't know that that's a blockchain concept or a fintech concept, but again, that's the co-chairman's prerogative. Kind of an interesting note too, along with Representative Greer, another piece that is silent and I think conflicts with our current probate code, and that is curious to hear how Representative Greer resolved the case with the client who couldn't physically sign a document, so how that was remedied. When we can't do any kind of video testimony or any kind of video documentation or even audio documentation, and that is not something that can be submitted to the court or considered to be any kind of record of testamentary capacity. So kind of an interesting current legislative prohibition when it comes to the creation of our probate intentions. So and found within our probate code. So curious concepts there that we are now jumping from an inability to even video document someone's testamentary capacity, but we're then allowing it to be diverted to another individual entirely. And so a really interesting concept.
Thank you, Senator. Any follow-up, Representative Greer? Mr. Co-Chairman?
Yeah, Mr. Chairman, actually, Senator Ellicott's point about digital evidence is a good one. Not trying to trigger Representative Lindholm, but he recently had a discussion with some of our justices regarding our rules of evidence and the fact that, that's a whole nother discussion. Our rules of evidence don't contemplate our digital world as a whole. They contemplate a paper world. Just like our statutes, as we were working through registered agents and registered agency issues, they contemplate a paper world. Just like in our filing world as attorneys, they contemplate a physical filing world and not an e-filing world. And so when you try to find the intermediary of simply just filing by email, it's amazing because, and this is no knock on our clerks or on our courts, it's just I'm just pointing out a reality. For several years, I and many members of the bar asked if we could just file documents through an email. And we were told the statute doesn't allow for it, and it doesn't because it contemplates paper. And then along came the COVID pandemic, and all of a sudden, every lawyer in the state of Wyoming could file their pleadings by email. And I think, I'm not certain because I don't do a lot of litigation, but I think my office is still doing that. And so, just a few closing thoughts. There's a lot of adjustments there, Mr. Chairman, that we have to make throughout law, whether that's rules of evidence or statutes. I mean, this is piece by piece. We just have to build it. And just to a further a thought there, Senator Nethercott, about whether you like the idea or not. Maybe I think I was channeling discussions that I've had with members of the bar, because that is the discussion I've had. In fact, I'll be very frank. The feedback I've received is this is the first time it's been substantive from a lawyer when Representative Greer wants to talk about a provision. Instead, the bar members that I've spoken to, they've simply said they either like it or they don't. And I think that same problem exists inside of e-filing. The reason why we don't have e-filing is not because technology isn't there or because the money's not there. It's simply because the majority of our bar is unsure of it and has been unsure of it for a long time. And so we've dragged our feet on it. The same thing is occurring here. One member of the bar strictly told me that our profession is sacred and that what we do is traditional, and that this would change everything. Just like when we got rid of legal-sized paper. Remember that, Senator Nethercott? I mean, those were traditions inside of our bar. So I'll agree there's a lot of work to be done here. I believe in the will of the committee. Same conversation I had about DAOs. At the end of the day, I brought this bill forward. It's my idea. I'm not gonna push something through and spend a tremendous amount of time trying to make this work for a committee that doesn't want it, and that's okay with me if the committee doesn't want to pursue it. So when I ask if you like the idea or not, I'm not asking whether you're committed to this bill as written. I'm simply asking whether you're committed to try to see if this will work. You're free to vote how you want at the end of the day, of course, when November rolls around. But if I'm going to invest my energy, and more particularly, if I'm going to go to LSO and I'm going to say, let's draft this, let's amend this, let's do this. And then in November, my members say, the idea, we're not ready for the idea. I'd rather just save everyone's energy and not exhaust LSO staff if the idea is not there. If I'm hearing that the idea is there, and we want to try to work it, then let's try to work it and get it as far as we can get it. And if we can't get it to the finish line, then we take it to another committee. Maybe it goes over to judiciary. Maybe whoever the new chairman of that committee is says, okay, that's a good idea. Let's take it on as a 2021 interim topic. I don't know. So we just keep moving the ball forward and we figure it out. But let's just, I mean, I don't want to kick the can for that eventual conversation where someone just says this isn't ready for prime time.
Thank you, Mr. Co-Chairman. Mr. Hopkinson, you've had more than three. Well, let me go to Joel real quick to weigh in on that, and then we'll get back to Mr. Hopkinson. Go ahead, Joel.
Thank you, Mr. Chairman. I had a question for Chairman Olson. I think the question of what this would be a precursor to eventually is what's on my mind as we discuss this. And there is a finite number of opportunities where this would benefit, and that's folks with wills in Wyoming. But then there is a much larger economic opportunity for Wyoming, which is the trust activity that happens in this state, both domestic and offshore. And I guess I think about the opportunities to have that development become electronic and ultimately on the blockchain as being very commonsensical. And I guess my question is an electronic will the very first step that's necessary for these other pieces to fall in place?
Thank you, Joel. I appreciate that. Senator Nethercutt, go ahead.
If I may, and I'll let LSO also follow up on anyone else who feels they can, but so a trust is a contract as opposed to a will, which is this testamentary capacity concept. And so under the Uniform Electronic Transactional Act, right, that we talked about, the UETA, you can sign remotely. And so those trusts can be done that way because that testamentary capacity concept isn't required. So does the electronic will piece dovetail into that? It certainly can. But in order to do a trust amendment or to do any of those trust pieces, it's just like signing an electronic contract. And so they can do that anywhere in the world and don't need to be physically present, because the high asset estates that we're trying to attract and do attract in Wyoming, they're not putting their assets into a will, it's through sophisticated trust documents. And so those wills, are just a pour over will in order to ensure that anything of high dollar asset that wasn't placed into the trust, which is probably unlikely for the type of consumer we're looking at attracting, would fall back into that trust. So it could dovetail in, but right now they're currently, I believe, allowed to remotely sign and have been since the 90s.
Thank you, Senator. Additional discussion? Go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. I just wanted to address Joel's question to me, which, I mean, yeah, that's the idea is not just wills, the wills and trusts. I don't really fully understand the concept that the will isn't a contract. It's a contract between me and myself. In the same respect that a trust, a single grantor, revocable living trust is a contract between me and myself. I just call myself a trustee and I call myself a maker. So I enter that contract. And so whether or not all of that is honestly, I think, irrelevant for the end goal of what I would like to see, at least in what I'm trying to envision, is a world where the same technology that underlines cryptocurrency, that is the blockchain, that same technology, that distributed ledger, can exist to, we've had this conversation since the beginning, to hold and authenticate real property records, for example. So the question is, can that same ledger be used to hold and authenticate other things? Contracts. Yes, I think we've all moved down that path. So where does the trust fit in? Probably more squarely there, because I think legally we'll all accept that as a contract the same as buying and selling or leasing real estate. So can it exist on the blockchain? Sure. The will, in my mind, is even more critical of a piece to move to the blockchain, because at the core of the will is its authenticity issue. That's what it is. That's what we're talking about, is that we want to know that this document that says that I give, when I die, my life legacy assets to XYZ. We want to know that it is real, that it is authentic, that it is that person's will, their desire, so to speak. And so if we believe that the blockchain distributed ledger is in fact more reliable and more secure of a record keeping process than existing technology, then why wouldn't we want our final wishes, our desires, whether that be how I pass my assets, or what if it's just whether I should have artificial hydration and nutrition, end of life decisions. All of these things we want to make sure are authentically the person's. Why wouldn't we want them on the ledger? And that's the world I eventually see. The wills on the blockchain is a much broader conversation. Although no state has enacted the Uniform Act that you have in front of you, 4 states allow for electronic wills, and we can talk more about that. But there's issues with those laws. And I think that ultimately wills on the blockchain will solve a lot of the issues that I think those states are seeing. And the commentary that exists out there is leaning in that direction. Again, I see this as an intermediary step to get us to that location. The same intermediary step exists right now for real estate. Before you could put them, they all have to be digitized before you can have a truly a smart contract, real estate on the blockchain, whatever it is. The first step is digitizing it and having a digital record. That's all we're doing right here is moving in that direction. So I've talked enough, Mr. Chairman. Thank you.
Thank you, Mr. Co-Chairman. Mr. Hopkinson, I think you were weighing in a few minutes ago.
Thank you, Mr. Chairman. I just wanted to mention that paragraph B on page 4, that is kind of a policy decision. We could take that out without any issues with the rest of the bill draft.
Thank you, Mr. Chairman. Is that the first paragraph B or the second paragraph B, just for clarity, or the third paragraph B? Which one of those would you favor taking out potentially as a policy option?
Lines 16 through 19.
All right, that helps to clarify. Thank you, Mr. Hopkinson. All right, one question I have, and it's for anybody who wants to weigh in, but Co-Chairman Olson, there are some unique challenges that we've identified with COVID where it seems like emergency allowances have been provided, but we still don't have any statutory clarity. And that would be, for example, the signing of the will with a witness present over video or something along those lines. That's in here. And that's something that we sort of ad hoc allowed for based on my understanding. And I'm wondering if there are some key components of this legislation that truly are low-hanging fruit, that we could implement them in a clean piece of legislation and get those done to take away some of the roadblocks while we contemplate the broader issue of a truly electronic will. And I clearly don't know enough about this space to know whether that's a good idea or not, but it's something I want to throw out to our folks that deal in this space, Senator Nethercott, Co-Chairman Olson, and Representative Greer, to find out if there is something here that we can just get done. Thoughts? Go ahead, Co-Chairman.
Yeah, Mr. Chairman, thank you. I would suggest that your intermediary step, if you want to back it up even further, is remote notarization, remote signature. So we already have legislation moving forward on remote notarization, not this committee, but the Wyoming legislature. I'm trying to locate it right now. Maybe Senator Nethercott or Mr. Kaufman or somebody has it more readily available than I do. But I seem to recall that the Wyoming Supreme Court had issued several orders regarding COVID. And if I'm not mistaken, I believe that one of the Supreme Court orders actually touched on this beyond notarization, but actually touched on remote witnessing and remote testamentary signing. Maybe I'm taking it further, or maybe that was just a discussion. I don't know, but I see Senator Nethercott wants to talk on that. But Mr. Chairman, if there was fruit that was available, I would like to have that discussion on just simply remote witnessing. That alone gets you pretty far, where you have an elderly individual with compromised immune system right now, real life scenario. They're in their home. They don't even want their lawyer to come into their home. They certainly can't have witnesses that they don't know come into their home. So how do you execute that will? And I thought the Supreme Court's order addressed that, but maybe Senator Nethercott could enlighten us.
Thank you, Mr. Co-Chairman. Senator Nethercott, thoughts?
I'm certainly, filled with self-doubt about that, having not studied the cornucopia of orders that came out of the Supreme Court. That said, I would be hard-pressed to find that the Wyoming Supreme Court, through emergency rule, has the ability to eliminate an entire statutory section in Wyoming statute for the very strict requirements associated with the creation of a will in our probate code. Maybe they did something, I don't know. I'm not aware of that, and don't think that is the case. I believe there was maybe conversations as a result of kind of the panic need to do it, and the fears about not being able to access hospital rooms where people were dying. I think most of that has subsided now. And of course, the conversation regarding remote online notarization continues, and legislation is currently underway under Chairman Lindholm's committee, the Corporations Committee, to get that all remedied through the Wyoming Secretary of State's office as well. And certainly a notary public is part of a will. And so that's a required step. But no, I'm not aware of any rules allowing for that. So it simply was that notary public piece, and really work through from the Wyoming Secretary of State's office.
Thank you, Senator Nethercott. And I'll ask you also, Senator Nethercott, though, do you think that we could accomplish that objective with a small amount of work, where we're amending existing statute and clarifying that, yes, this would be okay? Or do you think that we need to build like we've gotten this legislation through the Model Act, where we need a substantial construction supporting it?
Thank you, Mr. Chairman. My thoughts are, like Representative Greer and Co-Chairman Olson, I think this is a wonderful idea. And I think regardless of how I personally feel about it, which I personally like it, it's going to happen as a result of our digital world. I think this bill draft, and I think the Uniform Law Commission's efforts are terrible. And so I think it needs significantly more work. I think there is more harm than good to the public if we try to move something in an effort to make something electronic. And so with that, I would just urge a kind of a caution and a slowdown in just a year, really, to allow for the bar and the legislature to kind of more thoughtfully work it through based on our laws. So similar to what we did this morning, to Mr. Greenwood's kind of approach, who had also worked for an LSO, right? And it was obvious he studied Wyoming law first and then built upon that with the concept, instead of trying to force something external into our code. And that's what this is, by just kind of a straight adoption. And that's really dangerous because it really creates a lot of inconsistencies that ultimately result in harm to the people of Wyoming. And that's what we're trying to prevent here. So I think the harm outweighs any benefit, but I think the concept is good. I think we need to stay committed to keep working on it, but I don't think it's something we can get remedied for the 2021 session.
Excellent. Thank you, Senator. And I commented before, I'm not a fan of the Uniform Act. I think it was a good starting point for us to take a look at it and give some thought to this. But I think when you contemplate Co-Chairman Olson's vision of what we would like to achieve, I don't think this really captures that idea of, all right, well, let's put this on a distributed ledger. Let's figure out how that works and is implemented so that we can truly get to a next generation solution. And then how do we make sure that we've got all of the protections in place and appropriate legal considerations to enable such a thing in the long run. So we've got more to get to. Senator Nethercott?
To follow up with Mr. Ravel's comments and Representative Greer, who thinks this is an appropriate topic for this committee as well, and Co-Chairman Olson, interest, I think the utilization of blockchain when it comes to trusts and the associated pour over will is a really phenomenal idea, right? It makes a whole lot of sense. So all of those trust amendments that need to occur over time, are done in a way that can't be questioned. And I just really think that is a phenomenal idea, and look forward to watching that grow in the private commercial space, creating that particular blockchain for this particular usage.
Great, thank you, Senator. All right. Anyone else on this topic? And I don't think we have any public testimony on this topic. My apologies. Go ahead, Joel.
Thank you, Chairman. Just to follow up on that comment, Senator Nethercott, did I understand you correctly when you were speaking earlier that all of the legal framework is in place for that to happen, for that to develop in the private sector? Or is there something that we should be doing to address that?
Thank you, Mr. Reveal. Senator Nethercott?
Mr. Chairman, thank you. I think it's just a private sector initiative. Like all other uses for the blockchain, from health records to HR records to estate planning documents to real property records, right? All of those applications can be done commercially. So if someone wants to put their trust on a blockchain, they can, there's nothing prohibiting them from doing that. Now, what we might do, as you bring the question up, is to confirm in Wyoming law that if a trust is placed on a blockchain, that is considered, that those actions taken, reflecting the proper amendment process, the proper changes to that trust are actually done with, our legally recognizable actions in order to ensure that those are accurate documents, right? Are legitimate.
Thank you, Senator Nethercott. And that begs the question, do we need to do that? Or are we already in a position based on our previous statutory amendments where we really did try to thoroughly allow for a legitimate blockchain record to be considered to be equal to paper, we'll say, in most practices, but in this circumstance where we have a will, it seems like there's so much specific language around it that we might have question. And I don't know if the same thing exists on the trust side where there could potentially be exclusions, and maybe we need to explore this more as we move forward also. Senator Nethercott?
I would like to call on Representative Greer and Mr. Kaufman. They seem to be distracted, Professor.
Thank you, Senator Nethercott. All right, Mr. Kaufman, what are your thoughts? Do we have the statutory capacity at this point in time to have trusts on blockchain and associated contracts and agreements on blockchain? And I'll ask you the same question about wills, which it doesn't seem like we do. But again, we went to great lengths to ensure that blockchain and electronic contracts are equivalent to paper. So, Mr. Kaufman, what are your thoughts?
Thank you, Mr. Chairman. So, I'm a little bit indifferent, to be perfectly honest, about whether or not statutory change is specifically needed to do this. I'm on board, as everyone else is. It sounds like that this is a good idea to move towards, to clarify exactly how this could be done and the ways in which it could be done. But I mean, as we were just talking about earlier with the DAOs, I mean, entities now can take all types of agreements, governing documents, trust agreements, whatever you want, and digitize them and put them on some sort of a self-executing platform. So I don't really see, I mean, but to the conversation here, wills are just unique in that we have this statutory process with respect to how they're executed. That is different from everything else. And so if we can get around that, you know, I don't see a huge impediment here, but again, I'm a little bit ignorant because I have not admittedly spent a lot of time thinking or working in the area of how wills and trusts could be put on a blockchain. So I'm by no means the expert on that topic, but I don't see anything right now that would bar it.
Great. Thank you, Mr. Kaufman. Representative Greer, what are your thoughts?
In my view, now remember, trusts are a relatively new creature. I say relatively new, popular probably in the last 15 years, and extremely popular in the last 10 to avoid our burdensome probate process, quite frankly. Trusts are, again, contractual. I see absolutely no reason why the blockchain technology would not only is available without any statutory change, but it'd be a huge benefit to it. Wills are a complete different animal. And wills are ancient law, and the probate code in Wyoming and anything in our statutes dealing with wills have been held sacred with very few changes over the years. So if you're going to do something different with wills, you're going to have to take another step, and it's probably time to do so. How we go about doing it is fine, but we just need to make sure we do it correctly. You know, I think back to, so, you know, over 20 years ago, when you would see a trust, all the assets were held in a partnership, and then the trust held the ownership of that partnership, because that was the only way you could recognize the ownership, especially of real property and other assets, was it to be in a partnership. You know, those laws have slowly evolved so that now we have trusts directly owning real estate in particular, and the legislature has made those changes over the years to make trusts more workable, easier to deal with. I think it's a process. I think what I've heard from everybody on this committee is this is a good idea to move forward, but we need to move forward correctly and not, again, I think I said before, leave a huge hole or a gap that creates more than we solve. A lot of times too, I've seen or saw, I haven't been doing this last couple of years, but you'll see a very elaborate estate plan put together with multiple trusts for different reasons, either to protect assets, protect children from too much wealth, or avoid inheritance tax. And sometimes they'll be funded with a pour-over will, meaning that the assets weren't titled in the trust, but they were going to rely upon one simple document to make sure those assets go to those trusts. And if that one simple document under our law isn't executed properly, instead of going to those trusts and where the person who owned those assets intended them to go, they would go by intestate laws. So it is very important that we do it correctly.
Thank you, Representative Greer. I appreciate that clarity. And let's go to Joel. We do have a little bit of public comment on this. I want to bring in Mr. Marr in a second. Joel, go ahead.
Thank you, Mr. Chairman. I just wanted to, just staying on this thread for a second, suggest that perhaps at some point we could bring in Mr. Land from the Division of Banking. I know that he's currently in the process of working on a redraft of Wyoming's trust statutes and has been interacting with the Wyoming Trust Association. And this legislature has done a fantastic job over the last several years of increasing Wyoming's competitiveness as a situs for trusts, vis-a-vis South Dakota, Delaware, et cetera. And I think this is one area where we could continue to solidify that position.
Yeah.
I don't know enough about the existing trust statutes and how that may or may not fit with the idea of a blockchain record system for the trust, let alone smart contracts that execute the wishes of the grantor. But I think that Mr. Land may be able to provide some insight on that for us. Thank you.
Excellent. Thanks, Joel. And Mary Beth, please take note on that as well. That's something for us to explore moving forward and work with Mr. Land on ensuring that these ideas are reflected as we rework the trust laws. Go ahead, Mr. Co-Chairman.
Yeah, Mr. Chairman, just one final thought here, maybe before we move to public comment, and going back to is there some low-hanging fruit that we can do here? One thing we haven't really talked about is, excuse me, the concept of a holographic will, which I think is interesting, because a holographic will is one that abandons all of the formalities that we're talking about in the realm of the wills. A holographic will is recognized in every state and probably every nation that has will law. And it is simply that if I write in my own handwriting on a napkin, a piece of paper, whatever it may be, my final wishes, and it is in fact my signature, then it is treated no different than if I had paid Representative Greer or Senator Nethercott a bunch of money, thousands of dollars, to compose my will, and that they brought in a notary and they brought in witnesses, and we sat in a big conference room and we signed it. So maybe a small step is simply that. And I'm envisioning the decentralized world. I'm envisioning the folks out there who, just like in our conversation of DAOs, or our conversation of registered agents, just simplifying a creation process is really what the industry is interested in, at least in the commerce sector, being able to build these things without expensive third parties. Maybe simply put, that if a will was written in your own handwriting, but your handwriting, that's the thing what we're talking about, your handwriting is now code, and it is signed by you yourself. How is it signed? Not electronically, but with your private identification. Then it shouldn't be treated any differently than if I wrote it on a napkin. Maybe the difference is sophistication. Maybe the reason why jurisprudence says a holographic will is okay is simply because it's mostly going to be the unsophisticated individual and there's less at stake. Maybe that's it. But I know that at least the initial creation of the holographic will, or at least the recognition of the holographic will in law, was simply because we didn't want to deny an individual on their deathbed the ability to put out their final wishes if they couldn't get a lawyer and get witnesses and get everything rounded up. And in the 21st century, I can see the coder being no different, but maybe it's sophistication. I'm just throwing that out as some more thought on what we're doing here, Mr. Chairman. Thank you.
Thank you, Mr. Co-Chairman. Any further comments before we go to public testimony? This is a good discussion. All right, with that, Mr. Marr, welcome again. Please introduce yourself again. We'll probably have different people that are watching right now. So real quick introduction, and then let us know what your thoughts are.
Thank you. Can you hear me?
Yes.
Great. Thank you very much, Co-Chair Rothfuss and committee. I'm back. My name is Brendan Moore. I'm an MIT Media Laboratory alumnus from '98. I'm involved in computational law. I have a few entities in Wyoming, and I actually wasn't planning on joining, but I couldn't help that this dovetails on our prior conversations, specifically related to what we've been batting around, the blockchain-based registered agent. Really, this is about assertion of a signature and being able to ensure that signatures that are made permanent, right? Just as Co-Chair Olson has suggested, we're going in this direction where things at some point will be put on a chain. The questions become, how is that verified in terms of which chain? By what mechanism? We need an entity that acts as an intermediary to verify the signatures. And this becomes very important. So what I urge is that we begin to think about this idea of the blockchain-based registered agent that we were talking about earlier, not just for entities, but really as a signature and trust certifier. And this was batted around earlier. I believe Mr. Olson was talking about it in the context of verification of various things of trust. And I'll leave it at that. But it is, I think, the topic of the day.
Excellent. Thank you, Mr. Marr. And I think we all are, those on this committee certainly understand that this technology enables a higher level of surety than really anything else, but we have to build the process around it so it achieves kind of the legal desires and obligations, and particularly the legal traditions, as Representative Greer pointed out. So the technology is an incredible strength here. We need to figure out how to enable it so that we have the confidence, and it tends to get back to the idea of, you know, how do I know that this person was of sound mind, for example? Just because I used my my private key to sign something that I've then encrypted, put on the blockchain, we don't necessarily intrinsically or inherently have that same type of confidence. So that's the legal framework we need to build around this technology so that the two come together and harmonize. And when we get there, I think it's exactly as you say, this is a wonderful application for it, and it will be a much stronger system when we get these kinks worked out. Thank you, Mr. Marr. I saw someone's hand. Was it Senator Nethercott? Did you have your hand up? Yep, go ahead, Senator.
Just briefly, and then I think it's appropriate for us to move on. I want to make sure in this conversation that we don't conflate the concept of other types of contracts or documents with a will, a last will and testament. So
yeah,
it's a very different thing, and it's important to not conflate those pieces. And so that's all. Yep.
Nope. Strong point. Thank you, Senator. All right. Excellent. And thank you, Mr. Marr. I appreciate your participation once again. Any final thoughts as we wrap up this topic and move on? Mr. Co-Chairman, final thought? You good? All right, we're good. Excellent. Thanks, everyone. Thank you, Mr. Marr. Our next topic is intrastate crowdfunding exemptions. We have some draft legislation. We talked about this at our last meeting, and I think, unless anybody has any preliminary comments on it, and I know we have public comment on this topic as well, I think I'd like to ask LSO to walk us through the legislation. If Mr. Hopkinson would be willing to do that, we'll go through the legislation and take a look at it. Go ahead, Mr. Hopkinson.
Thank you, Mr. Chairman. I'm looking at 21 LSO 156, working draft 0.4, intrastate crowdfunding exemption amendments. And as we go through this, the committee requested this draft at its previous committee meeting with a few specific requests that we'll go through. We see, first one is we were requested to amend 17.4203A3A. And the amounts there, and that's on page 2, lines 13 and 14. We changed the amount from $2 million to $3 million. And over on page 3, lines 6 and 7, we were requested to change it from $4 million to $15 million. And certainly those numbers can be amended as the committee desires. On page 3, one of the other requests that we received was to remove the limit, the $10,000 limit on the maximum investment by a non-accredited purchaser. And we'll see on page 4, there's that staff note there. The way this bill draft removes that limit is by simply repealing paragraph 4. Alternatively, if the committee, there was also discussion about just increasing it from $10,000 to $35,000. So that staff note has that language amending that to the $35,000. And finally, we were requested to remove the reporting requirement and just have that information available upon request of the purchaser. And we'll see that on page 4 and 5. It was kind of a broad request, so certainly if anyone on the committee takes issue with the manner in which that's accomplished, as we'll go through here, certainly open to any thoughts on that. We see that being done here on subparagraph B. We get rid of, or it strikes on line 26, the quarterly report, and inserts information described in paragraph 4 of this section upon request of the issuer's purchasers. It further goes through each of those paragraphs. So essentially it changes the requirement of our quarterly report to simply providing the information upon request. It provides that the issuer shall provide the information free of charge. On page 5, paragraph 2, it amends it to require, at this point, at least the way it is that the issuer could satisfy that information requirement by making the information available on an internet website. That again is kind of a policy question if we want to do it that way or not. That's just kind of based on the language that was there previously. Paragraph 3 provides that the issuer must provide a written copy of the information to any purchaser on request. Paragraph 4 simply provides that the information provided, it changes it from report to information, must include all of the following, and the only modification there in subparagraph A strikes the language since the previous report on line 17, essentially requiring that they provide information about the compensation received by each director and executive officer, including cash compensation earned on an annual basis and any bonuses, stock options, or other rights or other compensation received. And this act on page 6, well, section 2, we see the language there repealing that $10,000 requirement, minimum or maximum, excuse me. And then the effective date would be July 1st, 2021. With that, I would stand for any questions.
Excellent. Thank you, Mr. Hopkinson. Any questions for Mr. Hopkinson at this point? All right, Mr. Kaufman. I'll open it up to you to make some comments. You know, this is something that we discussed last meeting, and you've spent some time working on this. Are you comfortable with this? Anything that we should be looking at, changing, any concerns you have? What are your thoughts?
Yeah, thank you, Mr. Chairman. So a couple of comments. I mean, overall, Mr. Chairman, I think the bill is incredibly close to what I had hoped to accomplish. You know, just a few comments to raise some issues for people to think about. Again, remember that under our WIN statute with the interstate crowdfunding, we have 2 tracks that companies can choose. We have a lower limit track where under this revision, you could raise up to 3 million, which was previously 2 million. If you choose that track, the burden on the companies is a little bit less. For example, you don't have to provide audited financials and things like that. And then there's the higher track where you can raise more money. It was previously 4 million. I suggested an increase. You know, the discussion led us to raise that to 15 million. While I would love to put it at 15 million, I think that might be a little bit high, Mr. Chairman, in my opinion. The reason I say that is that, you know, there's a lot of conversation at the federal level within the SEC about crowdfunding offerings anyways. And what I don't want to do is inadvertently put a target on people's back for raising 15 million bucks in an interstate crowdfund manner. And we sort of, you know, defeat the purpose of what we're trying to do. I think, you know, even 10 million would be a fantastic number, but I don't know. My gut reaction is that 15 million's a little high. I've even run that by a few other practitioners that I know, and I got for what it's worth, the same reaction from them. With respect to the staff comment and either the elimination of a cap on accredited investors or the increase, my personal preference would be to keep it at the increase and not eliminate it. Again, for the same reason that I think if you eliminate the cap, you're inviting scrutiny that we don't need for those transactions. So we're more than tripling it here. I think that's a reasonable thing to do. And again, I'll remind the committee that the reason that I was really passionate about this is I've counseled an awful lot of companies on their equity raises, and in considering the WIN statute in comparison to something like a 506C under our federal act, which is a Regulation D offering, you know, this is a limitation, and where the WIN statute at least allows you to have non-accredited investors, where a 506C doesn't. By raising that investment amount from $10,000, it makes it a lot more viable for companies to use it and to take non-accredited money. If the committee wanted to increase that, I think we could. I certainly wouldn't go any higher than 50,000. I actually think 35 is a very good happy medium. And just so the committee is aware, since we last met, actually, the SEC has announced a new revision on the definition of accredited investor. It didn't actually broaden it that much, so it doesn't dramatically change who qualifies as an accredited investor, but that rule is not in effect yet, but the SEC just literally published it in the Federal Register, so we've got a new definition coming, which hasn't happened for a long time. And then the last comment, Mr. Chairman, with respect to the reporting requirement changes, I just feel compelled to explain that a little bit because I know that might raise red flags with some people. But again, keep in mind, if you're a company and you raise money under a Regulation D exemption federally, there is no reporting requirement on an ongoing basis. You file an initial Form D with your exemption registration, and that's it. And so to have this reporting requirement for companies that choose to do an intrastate offering is creating a much higher burden on companies, and it's a disincentive, quite frankly, to use it. And so my suggestion was, you know, obviously these companies have an obligation to produce that information to their investors if the investors want it. That's implicit in the law anyways, but I think the way that these revisions read, it requires these companies to have that information available, to make it available. I think that's a reasonable accommodation, but eliminating that reporting requirement, I personally feel that will make this exemption a lot more attractive to companies that are looking. So with that, Mr. Chairman, I think with the exception of the 15 million, my suggestion being maybe lower that just a little bit so we're not attracting unnecessary attention. The rest of the draft I think is good.
Thank you, Mr. Kaufman. Does that mean 12 million or does that mean 10 million?
Mr. Chairman, I don't want to dictate the amount. If I was picking the number, I would probably say 10 million is sufficient. Again, I think we risk by pushing that too high, creating unnecessary, you know, scrutiny from the SEC.
What's the highest elsewhere in the country if there's limits in other states?
Mr. Chairman, we're already the highest.
You mean at 4 million?
No, I don't think. I think I'd have to ask the Secretary of State's office. They probably know better than I do, but I want to say 5 million is maybe currently the highest, or somewhere there, right around there.
Understood. Thank you, Mr. Kaufman. Questions for Mr. Kaufman? Any questions? All right. Seeing none. Is 35,000 the right number for the maximum per individual?
Mr. Chairman, I think 35 is a great improvement, a really great improvement. As I explained to the committee last time, I mean, I've counseled 2 clients that have gone through the WIN process. They've been the only 2 to do so far. And that number has been a big impediment, the $10,000 for non-accredited. Because the number is so low, it effectively eliminates companies from wanting to take non-accredited investor money because the transaction costs on that are just too high. So I think 35 is great. Like I said, I wouldn't recommend going higher than 50, but 35 is a great improvement. I'm happy with that.
And what about on page 2, paragraph A, where we're looking at the lower level of scrutiny, which was previously a $2 million cap? we're looking at raising it to $3 million. Is that something where we would want to increase that number? Is that the correct number? And imagine it in the context of us going to 10 million, which sounded like it was your comfort zone on the higher level maximum. So if we assume 10 million for the other, what would you say is the appropriate number here that wouldn't lead to harsh federal scrutiny?
So, Mr. Chairman, we talked about this a little bit last time. There's no reason, at least in my mind, that these numbers have to move in tandem. So I don't think it has to be 5 and 10 or some factor of each other. The lower limit is designed, and by policy of it is designed to be a small exemption. And like I said, with that, you get relieved of a few of the reporting requirements, like the audited financials. So 3 million is fine. Honestly, 2 million wasn't really that big of a problem, I think, for the lower limit exemption. It's more the higher tier that I think needs to be bumped up. So again, I've got no issue with 3 million.
Perfect. Thank you, Mr. Kaufman.
Yep.
All right, committee, before we go to public testimony, would anyone else like to ask any questions of Mr. Kaufman or Mr. Hopkinson, or any other questions on the legislation or discussion? Yes, go ahead, Representative Lindholm.
Thank you, Mr. Chairman. I really just wanted to voice how much I hate accredited versus unaccredited, and it bars people from their own wealth. And we're going to participate in that once again, but we kind of have to, so I get it.
Agreed. Thank you, Mr. or Representative Lindholm. I certainly can't disagree with you on that. Protecting you from yourself. You're welcome. Any other thoughts before we move on? All right, then with that, we have public testimony. My understanding is that Mr. Brock Pierce is here. He wanted to provide some testimony on it, so I'm going to invite him to start his video. And then if I'm not mistaken, we have additional testimony thereafter, so I'll double check with that. But Mr. Pierce, please join us. Welcome. Please state your name, a little bit of background for the committee and for those watching. Welcome to the Select Committee, and we appreciate your participation. Go ahead.
Well, I'd like to thank this committee for having me. My name is Brock Pierce. I'm an entrepreneur historically. I've built a number of businesses, and some of which directly intersect with this issue being discussed, these proposals being put forward. I was a part of the distilled jeans offering, which was the second Regulation A offering as an advisor and investor. I did that because I saw the importance of the Jobs Act and crowdfunding to democratize finance so that people all over the country with ideas could build those businesses wherever they are without, normally, if you were in Wyoming and you had an idea, you wanted to do something innovative, you had to move to San Francisco or New York. You had to move to one of these hubs to access capital. Because of the democratization of this, because of things like Jobs Act, entrepreneurs and innovators in Wyoming can stay in Wyoming and have the capital come to them. I think it's also worth noting that since we're in, call it the blockchain state, I was also one of the, call it co-founders, founding chairman of the Mastercoin Foundation, where we invented the ICO, which is what gave rise to the, do you have video?
We do have video. We've got you.
Okay, sorry, it was
You're
on my
good.
screen saying start video. And so having been on the forefront of the ICO market and utility tokens as a way of ideas receiving the resources they need, and having been on the forefront of the Jobs Act and crowdfunding, I was also one of the top 10 syndicates on AngelList for a long time.
Mm-hmm.
I founded the first venture capital firm in the blockchain space known as Blockchain Capital. And we invented and created and issued the first security token known as BCAP. So I think I have a fair amount of experience in this subject. And I think it's also worth noting that when companies like Microsoft went public, the private investors got 1% of the value. The public shareholders captured 99% of the value. And that's how things used to be. When companies go public today, the private investors normally capture half to 100% of the value, or more than 100%, and the public investors capture very little and find themselves often as the bag holders when it comes to innovation. You know, the financial engineers have gotten very good at extracting all the value before taking these businesses public, which means we have to democratize access to these types of investment opportunities if we want everyone to be able to participate in the economic upside associated with innovation. I commend this group. I commend this state for recognizing how important this is, that non-accredited investors, and I agree, it's like, it's your money. You should be able to invest it as you wish, and regulators should do what they need to do to protect people from bad actors. And there are bad actors. It's a pleasure to be able to speak before you. And I would encourage this committee and this state to continue to push forward. These are the things that will allow entrepreneurs and innovators to stay in this state and allow the capital to come to them. And it will also allow the citizens, the residents of this state, to be able to participate in the economic upside associated with innovation. So I applaud you and thank you for having me.
Absolutely. Thank you, Mr. Pierce. Any questions for Mr. Pierce? Questions? So, Mr. Pierce, I do have a question for you about, you do have a substantial amount of experience and background and have had to kind of forge the path a lot of times in the past. And we're trying to make that path a little easier to walk down, as you know, in Wyoming, so that if you want to be doing an ICO, if you want to be doing some type of fundraising, that you have an opportunity to do that through a token offering or other more modern vehicles. And the question I have for you is, what else can we be doing? What else should we be thinking about? And have you seen anything elsewhere that you've thought, boy, if only Wyoming were doing that, if only we had that in the United States? We obviously look to the community of pioneers and innovators for the ideas that we have put forward. And, I'd appreciate your thoughts on anything else that we can be doing along those lines to kind of lower that activation barrier.
Well, I continue to be blown away by how innovative and forward-thinking Wyoming has been beyond just this subject matter. I guess it's in the history of this state, considering that we just had a 100-year anniversary of women being able to vote, and that women's suffrage passed here, that you guys have created the LLC, that you've been enabling blockchain and cryptocurrency legislation, 18 laws and counting, your digital banking innovation. I mean, it's extraordinary to see government doing what it needs to do to continue to stay ahead of the curve. The world is changing, and it's changing rapidly, and we have to adapt and evolve with it. I'm blown away. I mean, what more to do? I guess just continue to do more of what you're doing and continue to be the leadership that we need in this country. A government that actually works together, that you can be from two different political parties and you can have conversations and collaborate and find a path forward to actually represent your people. I can't begin to commend you enough as a state for the work that you're doing, committees such as these, and how you're embracing the future. That is how you take care of your people. You're not just taking care of yourself, your civil servants. It might be worth noting that I'm running for president of the United States right now. I'm on the ballot here in Wyoming as an independent candidate. And so you are an inspiration to people like me, and just continue to keep up the great work. And to the extent that I can be of service and support you in any of these areas, I am here. I'll fly up here as often as you need. I'll be back on the campaign trail. I think a deal may have already been made today. I'll be buying a house, I think, here, just so that I can continue to show up in service, because you're showing up for your people and doing it so well that I want to make sure that I can do everything I possibly can to support you in that mission. I'm here to serve.
Excellent. Thank you, Mr. Pierce. We appreciate that. And it's great to hear that you're taking a personal involvement in the state of Wyoming as well. So we look forward to staying engaged with you as we work through this committee and with the other projects here through the university and business and industry around the state. Thank you. Questions for Mr. Pierce? Any additional? Go ahead, Representative Lindholm.
Thank you, Mr. Chairman and Mr. Pierce. Appreciate the comments. I think it's think it's pretty exciting what's going on in the state of Wyoming. I'm actually kind of excited that you're here because the reality is, for those of you that don't know about Mr. Pierce, is he's kind of the guy to follow. He's a trailblazer. He does some pretty wild stuff, and he's gotten some stuff done. So it's exciting that you're now looking at Wyoming. This is the attention that we've been looking for, and this is the results that we start to see happening. So I really appreciate that that you're here, and I hope you make Wyoming your primary residence so that you don't got to fly back and forth that often. And the reality is these folks are going to keep moving the ball and keep passing good legislation that makes it easier and easier to do business in the state of Wyoming. That all being said, in regards to citizen involvement, we spoke specifically around accredited versus unaccredited and those types of aspects. Now, granted, we don't take those into consideration when it comes down to digital assets, and that does seem to be your expertise. However, being able to invest is something that you've done quite a bit of also. And so you spoke about the public versus private aspect. Do you see any kind of, do you feel, I guess the question would be, do you feel that crowdfunding is much like ICOs starting to trickle off a little bit and something new is going to arise out of that? Or, I mean, our goal has always been to skate to where the puck is, to quote Miss Long, or where the puck is going to be. So any advice there would be exceedingly helpful.
Yeah. So
Representative, go ahead, Mr. Pierce.
Yeah. So when you're on the forefront of innovation, you know, there's a little bit of that kind of start, stop, where you kind of go through these peaks, you know, and valleys. You know, they take, you know, they're difficult to time. It is what it is. And we go through waves. So you take the ICO market. We had a huge wave of ICOs. And when, you know, things start to become that successful in that short a period of time, it starts to attract a lot of the wrong elements. And people start doing things not in the best way. And then there has to be a market correction. And then we as a market figure out how to improve upon the idea to protect the communities, to protect the constituents, to protect the participants. At least the very good actors do that. You know, we kind of self-regulate a little bit, clean up our market so that the market, you know, has a resurgence. We were then in a bear market generally for cryptos. We're now into what I'd say is a bullish market, not a bull market, but the water is warm. And I think that we're going to quite likely see that next sort of wave of what I'd say ICOs. These are the utility token based sort of offerings where people are seeking resources to fund projects, protocols, open source ideas, not securities. On the security side, the crowdfunding sort of deals have, part of the problem is that there's a long path to liquidity when you invest in these early stage deals. And that's a turnoff for a lot of people. And so, you know, we've seen some progress there. I do think where those things meet, I think as security token offerings come together, where you're essentially taking, you know, the reason why big companies go public and small companies do not is because of the overhead, the cost of being a public company. What security tokens do is they lower the overhead of essentially allowing those securities to trade in a liquid market. And so I think where, you know, crypto and blockchain meets security tokens and Jobs Act, that's where I think we're going to see the widespread appeal. You have the ability to invest in early stage businesses. I also think coming out of COVID, considering all these small businesses and how they've been so negatively impacted, if we want to rebuild America, right, if we want to continue to support the American dream, a lot of small businesses are gone. And we, the people, are going to be the ones that bring them back. You know, these restaurants, you know, where are they going to get their money from? It's going to come from the best customers. It's going to come from the people locally in that community. They're like, we want you back. We love you. Oh, you don't have the money? Here, we'll essentially finance you. And maybe we get some gift certificates and things for it. I think that security tokens are going to be an interesting, I think that's when we're going to see the next really big boom. We might see, you know, some smaller things on both sides, but I think where those two meet is where the biggest opportunity lies in the years ahead.
Excellent. Thank you, Mr. Pierce. Go ahead, Mr. Kaufman.
Thank you, Mr. Chairman. Mr. Pierce, you just struck a chord with me. I wanted to ask you a follow-up question on that, because following up from Representative Lindholm's question, I mean, we really have ridden the wave in Wyoming. I mean, 4 years ago, we were seeing a ton of this ICO action. And I think people, of course, as you know, thought that it was a way around securities laws, and the SEC quickly shut that down. People are slowly acquiescing to the idea, you know, in the space of, okay, we're a security, let's run with that analysis. What I'm interested in is the overlay of the two, you know, and we're seeing, or at least I'm seeing, a lot of companies navigate those waters of, we have a token, we have a project, we have something that we want to do. We might need to raise capital though in the short term. How are those happening simultaneously, or should they be happening simultaneously? Is there a way to combine them? Obviously, you're familiar with all of the efforts along those lines. I'm really interested in two things. One, do you think there's anything we could be doing in that space to sort of jumpstart that bridge? And then secondly, you know, there's all this activity going on with DeFi right now, and regulators have no idea what to do, I don't think, with DeFi projects. And is there a way, or is there anything that you're seeing out there that Wyoming could be doing to help accommodate, not only accommodate the projects, but accommodate regulators, you know, to create, we keep calling it the sandbox, but to create this sandbox where those DeFi projects could thrive?
Yes.
So, go ahead, Mr. Pierce.
Yeah, keep creating those sandboxes, you know, for the good actors that want to do things in a good way, you know, allow them to come do things in an environment where there's oversight. You know, that keeps the bad actors away, because there's plenty. And how do we differentiate them? I have to keep commending you for the innovation and the embracing and forward thinking of this committee in this state and what you're doing. Create that sandbox for decentralized finance along the lines of what you've been doing. Create that sandbox for security tokens. Get those security token exchanges to come incorporate and set up shop here. You know, these security token exchanges are going to be a very, very big thing. I mean, with what you're doing with digital banking, crowdfunding, blockchain, I mean, Wyoming could end up being a very, very important financial services hub in the world. We are living through the fourth industrial revolution, and there are going to be winners, and there are going to be big winners. New York, London, and Hong Kong are the way they are because they were at the forefront of innovation. And if you continue to do the work that you're doing, I see a very, very bright future for the state of Wyoming. And it's not just for what you're doing here. I mean, looking at the farmers and looking at the ranchers and beef chain and projects of that nature, figuring out how to make, you know, family farms and make these businesses, make their products more desirable, to increase their market share, increase their revenues, to put more money in their pockets. Technology is a tool to enhance our lives and to enhance our businesses. And you're doing it across the board, less so in the blockchain, but the coal industry as well. You know, the fossil fuel industry and energy is a big industry in this state. And innovation is the answer. There are 21st century solutions to our 21st century problems. You know, carbon capture, there are ways to keep those coal plants operating, keep those jobs preserved while we think about the future, but to do an orderly transition, one that is not disruptive to the people. And with carbon capture technology and innovation, again, there is a way to preserve those jobs and preserve the environment so that we can, in a more orderly fashion, upgrade our systems while protecting the residents of this wonderful state.
Thank you, Mr. Pierce. You know, on that last question with decentralized finance, if we're looking at trying to sandbox that or do work in the state of Wyoming, most of the barriers there tend to be SEC barriers instead of things that we can directly engage in. And we've spent a lot of time trying to work around what we are allowed to do. So the question I have is, what can a state do in addition to what we've already done with securities coins as opposed to you know, consumption coins, open blockchain coins like we've got right now? What steps could we do that would be enticing in terms of setting up one of these exchanges in Wyoming? How could we further enable that business model?
Well, I think it starts with what you've been doing, which is, you know, put the message out there, you know, continue to create awareness that this state is welcoming innovation. This state wants to embrace innovation. This state wants to work with those innovators and to come set up that business here. By putting that out there, you know, your phones are going to start to ring and you're going to have a bunch of, you know, people taking an interest, because you may not have all of the authorities necessary to make this happen. But as an entrepreneur operating in markets with lots of uncertainty and regulatory uncertainty, it is a very uncomfortable place to be on the forefront of innovation when you know that you're under a microscope and regulators are looking at you, and not just regulators, US federal regulators. It's a reason why we have a lot of innovation and a lot of entrepreneurs leaving this country. They've been leaving because we have not made it a safe place to operate. And thanks to Wyoming, you're giving entrepreneurs some comfort that at least you've got allies. You've got people that are willing to work with you and willing to say, hey, no, we're familiar with what's going on here. We've spent time with these entrepreneurs. It may not be clear, but your views matter. You know, the federal government is going to listen to you. You may not have the authority to make things happen, but you're able to provide an environment that gives people the comfort to come innovate here. It doesn't need to be you've got all the answers and you can provide everything they need, but knowing they've got allies, knowing they've got a state that is looking out for what they're doing, that understands what they're doing and is there to support what they're doing, knowing that it's a process and an ongoing dialogue with the federal government. I think that that's almost all you've got to do. You know, we know as entrepreneurs that we're entering uncertain territories. We know that most of the time our businesses are going to fail. We just don't want to ruin our lives in the process.
Excellent. Thank you, Mr. Pierce. All right. Any final questions? All right. Go ahead. Representative Lindholm.
Yeah, thanks, Mr. Chairman. I don't really have any final questions. I do have a final thought in regards to it's federal law, it's Securities Exchange Commission, yada, yada. We got where we're at because we didn't pay attention to federal regulation. We just said, you know what, let's amend the Uniform Security Act, which we ended up going back and fixing. So I guess, Mr. Chairman, I think when it comes down to decentralized finance, I think that that has extreme merit, considering the amount of money that's moving in that direction right now, to at the very least look at creating some type of a model. This could be 34, 29, 107, because right now we're only up to 106, which is the Wyoming Utility Token Act, where we blaze ground in regards to actually calling it a utility token in law. So I think there's merit there. And so I guess I would just, Mr. Chairman, I would just ask the committee to put their thoughts, their thoughts together on that, because essentially what we're talking about is an exchange and how we, maybe we amend something around a broker. I don't know.
No, it's hard to say, Representative Lindholm, but I certainly agree with you. I see Senator Nethercott, and then I see Ms. Long. Go ahead, Senator Nethercott.
Thank you, Mr. Chairman. Just to kind of follow up with Representative Lindholm. So, you know, he says we just disregarded federal law, and we did in some ways, but we also did the opposite. Where we studied, examined, and considered federal law in order to fully appreciate where Wyoming could create a space within the limitations of federal law, in order to drive a conversation, right, and to drive this issue. So it's not a complete rejection or ignorance of the application of federal law in Wyoming or across the country. Not that that's what we did, but it is acknowledging our limitations, but recognizing where Wyoming can carve out a space in light of that federal limitation.
Excellent. Thank you, Senator Nethercott. Ms. Long. And then back to Representative Lindholm. Go ahead, Ms. Long.
Thank you, Mr. Chairman. I think the most important thing we could do in this area is to enact the legislation authorizing DAOs. Because one of the problems with and DAOs, again, are decentralized organizations. It was the topic that we talked about this morning. One of the problems with these projects is that it's possible that a judge considers them to be a general partnership, in which case everybody has joint and several liability. And that's one of the reasons why folks don't want to do it in the United States, because they don't have anything that protects them in the event of being deemed a general partnership. And so that's why I think that amendment to the LLC law would be really important. Secondly, actually, in the legislature's wisdom and the Wyoming Banking Division's wisdom, guess what? The Speedy Bank legislation authorizes exchanges for security tokens. Speedy Banks already can provide custody services and exchange services around those. And because it's a bank, the Speedy Banks are exempt from a number of the SEC registration requirements. So a lot of people don't really understand the power of the Speedy Bank license, but there is a lot that can be done in the Speedy Bank license. One of the challenges with the Speedy Bank license, though, is full disclosure, I'm going through the process almost to the end, and it has been brutal. It is not easy. And as you all know, because we've heard the testimony multiple times, the Speedy Bank license actually opened for applications October 1st of last year. And in the beginning, nobody came. And that's part of the reason I started one. I'd committed both to Commissioner Faulkner and Governor Gordon. If nobody showed up, I would do it. And boy, it's taken a while. And luckily, they are showing up now, but it took the first one getting through. It is a very tough process, and the capital requirement is very high. Commissioner Faulkner has testified multiple times that there were about 150 inquiries. And when we stop and think about why there were 150 inquiries and nobody started the process after almost a full year, that's maybe where we need to be spending some time, is thinking about why is it so difficult to get these bank charters. Now, I also understand that a lot of this is a function of the Federal Reserve's requirements, and there's only so much that the state can do. But as we talk about making the process more efficient, there are a lot of inefficiencies and bureaucratic things in that process, manual things, a 20-day period here, waiting for a court transcript of a hearing there, that just delays the start of these new businesses. So it may be that just creating a more streamlined and more efficient process that would still comply with what the Federal Reserve expects in terms of the depth of investigation by the regulators, may actually help on that front.
Excellent. Thank you, Ms. Long. And again, I'll just make a note, Mary Beth, if you want to make sure that's kind of recorded in the minutes and we flag that as this whole topic of decentralized finance and securities, crowdfunding, tokenization, as something for us to really find ways to optimize in Wyoming as one of our topics for the future. I'd appreciate it. Yep, go ahead, Representative Blinto.
Thank you, Mr. Chairman. I appreciate, I just wanted to say I appreciate Senator Nethercott's comments. She's kinder and gentler than I am in regards to what we were able to do to federal law. I think, I mean, we didn't ignore it, Mr. Chairman, but we dang sure exploited it. Or maybe we call it a hack. Maybe we're all a bunch of hackers now. But that's the reality when it comes to security law and what the state of Wyoming legislature was able to do. On that point, in regards to decentralized finance and these exchanges, there's essentially two places in the law that we could take advantage of that. Ms. Long just mentioned one in regards to the Speedy Bank aspect and application, and that's a very long, arduous route. Or we just define facilitator under our existing law, which could be in Title 34, but that might, because that's essentially what these guys are. They're just facilitating the exchange between two entities. So that's just more to think on. Appreciate the conversation. I think it's great.
Absolutely. This is a great topic. Thank you, Representative Blinto. Anything further before we take we need to work the legislation first, and then we'll take a break thereafter. Anything further before we go to the legislation? All right, seeing none. Thank you, Mr. Pierce. We appreciate you joining us for this discussion and presentation in support of the legislation. And with that, we'll close public testimony. Well, let me check with Mary Beth first that nobody showed up. Mary Beth, did anyone show up without me noticing?
Mr. Chairman, I'm not sure if the Secretary of State's office wants to comment on this particular topic, but they are in the meeting.
Okay. I don't think they do. I got a note from Deputy Wheeler, although they are here. So let's check in with them and give an opportunity to see if they want to weigh in. Welcome, Secretary of State's office. Please, as always, you know the drill. Introduce yourselves and We welcome your testimony and input.
Hi, Mr. Chairman. Thank you very much. Kelly James, Compliance Division Director. And I have with me Cody Gerhold. She's our Outreach and Education Coordinator, and we appreciate the opportunity to make comments. We'll be brief. We do support the crowdfunding revisions overall, with the exception, of course, that we do not want the cap removed. And as Mr. Kaufman explained, we do feel that that needs to stay in there. We did pull the numbers from all of the other states, and the 5,000 to 10,000 is almost every single state is that limit. There are some that go down to 2,000. The District of Columbia actually goes up to 25,000. And so 35,000 is high for Wyoming, but we do just want to make sure that there is a cap there. As far as the offering limit, Mr. Kaufman was correct, 5 million is the highest. And there are 3 states that have that right now. So we would like to see it more close to the 7 or 8 million. Mr. Kaufman mentioned 10. That would definitely put us at the very high end of that legislation, but that's fine. The reporting requirement, we did have an ask on that one. We are fine with the report not being required to be filed, but on page 5, under section 3, line 13, we would just request that it would be to any purchaser or the Secretary of State on request. That way we would be able to also see that report if we wanted to request it.
Thank you, Ms. James. That last point, just point once again, now that I've got myself on that page, to where you made that suggestion.
Yes, Mr. Chairman, on page 5, line 13, we would just ask that it would read information to any purchaser or the Secretary of State on request.
Gotcha. Thank you.
And that is really all of our comments. We appreciate Mr. Kaufman working with us on this, and I will stand for questions.
Wonderful. Thank you, Ms. James. Go ahead, Representative Lindholm.
Thank you, Mr. Chairman. And Ms. James, in regards to the page 5, line 13 that you just spoke of, I mean, that wasn't, the Secretary of State's office wasn't mentioned before in the prior legislation. I'm assuming the reason why is because you have an audit authority on these entities. So is it necessary to insert that there when you, the way I understand it, you've already got this authority. Can you talk to that because it wasn't there before?
Go ahead, Ms. James.
Mr. Chairman, Representative Lindholm, yes, I mean, it was required that they filed it with us, and that was the requirement that Mr. Kaufman wanted to remove, and we are fine with that. We just want to have the ability to request it if we need to.
Thank you. Follow up, Representative. You good? He's good. All right. Any additional questions for Ms. James? All right. Seeing none, thank you both. Appreciate having you here today. And I know we'll hear from you again in a little bit. So look forward to it. Thank you. Mary Beth, anyone else for us?
Mr. Chairman, there is no one else.
Excellent. Okay. Thank you very much. Then with that, committee, what's your pleasure?
Move the bill.
Move the bill.
All right. We've got a motion by Lindholm, a second by Ms. Long. Discussion on the bill before we start walking through it. Go ahead, Representative Lindholm.
Thank you, Mr. Chairman. I think this is a step in the right direction. I hope crowdfunding still is a thing in the future. I think it's you know, a great way for smaller companies to be able to raise funds. I will be bringing an amendment to remove the cap, though, on how much you can actually put in. Right now, it's currently at 10,000. We're bumping that to 35,000 for non-accredited. I still think it's inappropriate that we limit how much somebody can spend of their own money. I know that that's probably going to make the regulators a little nervous because we've got to play ball, and I'm just not interested in playing ball. I think it's an issue.
Thank you, Representative. And Representative, I'll point out that as drafted, there is no cap. The staff comment is where the cap was inserted as an alternative that is available so that it's clear if there's a choice to amend it to 35,000, that it would be a reinsertion of what we see on page 4, lines 10 through 23, and then we would have to remove the repealer as part of that motion if that's the committee's decision. So as it stands right now, it's in the position that you suggested you favored.
Oh, perfect. Sorry, Mr. Chairman, my bad. I was reading
No
too.
problem. No problem. All right. And with that, any further discussion or questions before we go through the bill? And we'll take amendments as we walk through page by page. All right. Seeing none, we've got a motion on the bill. We're going through. Any discussion or amendments on page 1?
Question on the bill.
Any discussion or amendments on page 2? All right, that's the 3 million number. It sounds like we're all comfortable with that. We're now on page 3. This is where we have the $15 million figure. There was a suggestion by Mr. Kaufman to change that to 10. Is there a motion to do so? Got a motion by Mr. Kaufman and a second by Senator Nethercott. Discussion on the motion. The motion is to change page 3, line 8 from $15 million to $10 million. Discussion. Go ahead, Ms. Long.
Thank you, Mr. Chairman. I can't tell you the number of very, very wealthy people who have recently disclosed that they have moved to Wyoming. We just heard a testimony from one that he just purchased a house here. I don't know if he's changed his residency here, but it's not just in this industry. As you know, it's Silicon Valley, it's New York. Just the number of people coming into this state. I think that when the tax information comes out about 2020, how many people relocated here and report this as their residency is going to stagger everyone in terms of the income that has come into this state. And so we really do have a good reason to have a high cap, because there are a lot of people who will and are capable of supporting startups at that level. Thank you.
Thank you, Ms. Long. Representative Lindholm, your hand was up.
Thank you, Mr. Chairman. My excuse is not as near as good as Ms. Long's, but it's along the lines that a recent printing or quantitative easing of $2 trillion has probably devalued our dollars, and $10 million ain't worth what it used to be. So I think 15 million is more appropriate.
Yeah, my coffee actually cost $7 million, so it's an accurate statement, Representative Lindholm. Good point. Senator Nethercott, go ahead.
Yeah, thank you, Mr. Co-Chairman. I just want to kind of call on some of the other members of the committee, like Mr. Ravel, his comments. I'm curious to hear his thoughts on the topic. And Representative Yin, have you seen additional people coming into your county? Or Driscoll or Senator Dockstader to just some policy concerns or conversations about this, and just curious for that feedback.
Great, thank you, Senator Nethercott. Let's run that group then. Mr. Ravel, what are your thoughts on this change?
I'm in favor of this change, and I will add to Ms. Long's comment earlier about the influx of potential investors and supporters of these sorts of opportunities. It's been staggering, and I think it's only going to continue, if not accelerate.
So, Mr. Ravel, does that mean you want the 15 million or the 10 million? Because the amendment is to take the 15 to 10.
I'm okay with 15. Thank you.
Thank you, Mr. Ravel. We've got fist pumps from Representative Lindholm. We need more high-fiving. That's honestly one of the problems with the Zoom atmosphere, is that it precludes high fives, which have been a staple of this committee and task force over the years. So somehow we need to figure out how to return to that. Representative Yin, you were queried as well?
Sure, yeah. I mean, I could comment on the number of people that have been buying houses this year, but I think everyone's well aware. What I would say is that if we invite more scrutiny than necessary, to Mr. Kaufman's point, we run the risk of just getting this overturned in full, right? So I think, in my opinion, I'd like to go with the safer route, see what it does. And, you know, if it feels like we need to raise it again, then we can do that in the future. So I'm voting for the amendment. Thank you.
Thank you, Representative Yin. We'll go around a little bit more in a second, but I did want to ask Mr. Kaufman, and he has expressed concerns that we would receive some unwanted scrutiny for this program. is there an approval process, or what would happen? Let's say we had an absurd number here and it was $100 million and we drew all of the wrath of the feds. What does that mean? And are these sanctioned programs, the WIN program and these intrastate crowdfunding programs, or can you describe a little bit to us how that might play out if they became unsettled?
So I'll just give you the 30-second history, Mr. Chairman. So Mr. Pierce referenced the Jobs Act, which was really a game changer in terms of how small companies raise private equity, because the policy has long been in this country under the Federal Securities Act that you cannot generally solicit, meaning you can't go out there and contact people you don't know. The law actually says you have to have a pre-existing relationship with people that you raise money for or money from. And so that limits it to your personal network. Everybody's heard the saying, friends and family. Well, that comes for a reason, because that's who you're supposed to be theoretically raising money from in a private offering. The Jobs Act changed that dramatically, because when it created crowdfunding, what it said was, well, for the first time, you can now generally solicit. You could put it on Facebook or LinkedIn, or run a newspaper ad if you want, where before you absolutely could not do that. But what the federal government did was create very, very strict limitations in the Federal Crowdfunding Act of how much you could raise and how much particularly non-accredited investors could invest. And so as that's evolved, now we have other offering exemptions for larger amounts of money. There's multiple regulations. And so my only concern is an offering like this, where a company is taking both accredited and non-accredited money. Companies, their practice is typically to do everything they possibly can to fly under the radar of the SEC and to make that offering in a fully disclosed, compliant manner. And so my fear is that if you get too high with that and you get too carried away with non-accrediteds and with the amount of money from non-accrediteds, that you sort of scare people away from using this. Conversely, I totally appreciate and agree with the comments regarding raising money and new investors here. My only response to that is there are other offering mechanisms if you're only going to raise accredited money. I mean, we just did one of those for a company last month. They had 6 investors and everybody put in $500,000. But not everybody has the network to do that. And so that's what the crowdfunding mechanism is really for. It's to allow you to generally solicit. And so with that general solicitation, though, comes some increased risks for companies. And so that's what just makes me nervous, is getting too far out there where we scare people out of that. But that being said, this isn't such a big difference that I'm going to die on that hill either. So I hear what everybody's saying.
Thank you, Mr. Kaufman. Mr. Majority Floor Leader, Senator Dockstader, what about your world?
Thank you, Mr. Chairman. Stay with the safe route, but yes, we're seeing, not specifically because of this, we're seeing a real uptick in people buying and moving in, as exhibited through our internet services here, which are high speed. I just talked to that company and they said all of their new hookups, virtually all of them, are from out of state, many from the East Coast.
Interesting. Thank you, Senator. And Senator Driscoll, what are your thoughts?
I'm all in at 15. A little bit of scrutiny is not going to hurt us. I think we're on the radar already.
All right. And obviously, I'll just note, anybody who's watching, this is obviously not the end of the conversation either. So we're setting the original drafting position, and we would anticipate having more feedback and scrutinizing this number more. So whether we send it forward with 15 or 10, it's a good bill. All right. Any further discussion before we vote? So the amendment, just to clarify, is to take it from 15 to 10. If you vote aye, it will be a vote for 10. If you vote no, it will be a vote for 15. All those in favor of the motion, please signify by putting your hand up by the screen. I see 1, 2, 3. Those opposed, hand by the screen. 1, 2, 3, 4, 5, 6. I see 6 votes. So the motion has failed, and it stays at $15 million. All right. Anything else on that point before we move on? Any other amendments on page 3? Seeing none, moving on to page 4. Page 4 currently stands as no ceiling. Is there any discussion or motion? Mr. Kaufman, go ahead.
Thank you, Mr. Chairman. I would make the motion to bring section 4 back in with a limitation. Yeah, for the same reasons I just stated about the 15 million, I get a little bit nervous about completely removing that cap. So I would make the motion to bring that language back in.
Okay, is there a second? We've got a second from Representative Yen. Any discussion? And again, I will assume that this motion also includes removing the repealer later in the bill, which is necessary for conforming the amendment and then conforming the paragraph B accordingly. So with that discussion, Representative Lindholm.
Thank you, Mr. Chairman. And I love making Mr. Kaufman nervous. No, I'm joking. I really don't. And I do appreciate everybody's thoughts that maybe a cautious approach is better. But especially in this regard, the state of Wyoming should stand up and say, it's your money, it's your property, do with as you please. And this unaccredited versus accredited garbage has haunted people and been a barrier to wealth for low-income people forever and ever. Amen. And that's a problem. Now, granted, a lot of low-income people don't have more than $35,000 to invest, but they might have a windfall through a relative that passed away or something like that. And because they're not accredited, they at that point would be stuck at 35,000, which is still even better than what it is now. But both are wrong. Both are immoral. I think that's where Wyoming should stand up and receive that extra attention based on this aspect. And I know Mr. Kaufman's just being cautious, and I super appreciate that. But I also know that he does agree with what I'm saying. He just doesn't want to say it. But that's the reality, Mr. Chairman. It is so it is wrong to tell people what they can and cannot do with their own money. And I don't think Wyoming should take part in that. And this is one little step that we can step away from that. That's great.
Thank you, Representative Lindholm. Representative Yen.
Thank you, Mr. Chairman. I think, in ideology, I would agree with Representative Lindholm. Ultimately, it's your money. You should do what you want. I think there is a better way that we could do this with regards to raising this limit from more than 35,000. The question is what it becomes, what is the number where we can still keep that border of accredited, unaccredited? I'm an unaccredited investor. So if I wanted to do more than 35,000, I think I should be able to. But the question for me is, where can we go with the statute to raise that number high enough where it will capture pretty much everyone who is an unaccredited investor that wants to invest in these businesses, while still keeping that line in the sand of accredited, unaccredited, just so we don't fly too close to the sun as Icarus did.
Thank you, Representative Yen. Representative Greer, we're on 21 LSO 156 intrastate crowdfunding exemption amendments. We're working through the bill. We've already taken public testimony, and we're on page 4. We're discussing whether or not to have a cap on accredited investors, which the amendment that's proposed is to end up with a $35,000 cap on, unaccredited investors. I misspoke. Or to have no cap, which is the default position. So an aye on the amendment would have a cap of $35K. A no would not have any type of cap on what an unaccredited investor could do. And with that, let's go to Mr. Kaufman.
Thanks, Mr. Chairman. Sorry to keep talking here. I just wanted to raise the point that this issue is, quite frankly, more important to me than the amount of the raise. And the reason being is this: when a company is raising money under any securities laws and they take money from a non-accredited investor, the remedies available to that non-accredited investor are typically higher and more extensive than for accredited investors. as are the disclosure requirements. That's why so many offerings are limited to only accredited investors. And that risk is extremely exaggerated, in my opinion, if you all of a sudden now allow companies to take money from non-accredited investors and they're putting in, their entire life savings. I totally and completely understand and sympathize with the sentiment that it's your money. You get to take the risk that you want. The problem is the other side. It's the companies that get hit with that liability risk. And I think what you will see is companies saying, never mind, we're not going to take non-accredited money at all because it raises that risk profile. So when there's already a cap on it, the companies get to rely on that cap as sort of, an argument to say, well, we're within the exemption. So again, I believe it's important to have it in there. I personally agree with the sentiment, but in the spirit of trying to do these offerings in a compliant manner and get people to use them, I think it's important to have.
Thank you, Ms. Long.
Thank you, Mr. Chairman. I would agree with Mr. Kaufman, but that's not a state constraint, that's a federal constraint. And we all know the reality is that people will comply with the federal laws because their attorneys are going to advise them to do that. That doesn't mean the state should have a constraint on. So since the federal law is the gating item anyway, realistically, I don't know how many people will use it if they go well above the cap. But by us not having a cap, we're just making a statement. We're taking a stand. It's kind of like the ICO bill. In the end, the SEC, trumped us essentially and made it such that there were not a lot of ICOs that ended up coming into the state of Wyoming because of the way the SEC handled it. The same thing's happening here, but that doesn't mean that the state shouldn't take a stand because candidly, I think in that situation, we did push the ball down the field. We did actually help make the SEC take a stand, and they ended up probably better, more investor friendly than they otherwise would have landed if we hadn't pushed them.
Well, Mr. Kaufman, I have a follow-up question based on what Ms. Long said, which is what are the implications when you interact where our statute would be if we had no cap with the SEC accredited investor versus non-accredited investor, and would we end up endangering our companies without a cap, or would it just default to federal interpretations at that point?
Well, I totally hear what Ms. Long is saying and don't disagree, in principle, but Wyoming has adopted, the majority of the Uniform Securities Act. And so to the extent that our state regulators are able to administer a program like this, we're still doing that under the context of all of the adopted federal definitions and, the baseline, essentially backbone of the Federal Securities Act. And so again, to take this one piece and sort of kick it out there, I think personally it becomes a problem. The other problem, and I don't mean to get technical, but when companies do offerings one right after another, they run the risk of a doctrine with the SEC called integration, where the SEC can combine those offerings together for purposes of evaluating compliance. And so again, this, because now you have no cap on accredited investors, I think it makes it a more difficult argument for companies if they find themselves in an integration context. So the bottom line is it creates a lot of complicating factors in my mind. If a company is called under examination or sued for it, what's the likelihood of that happening? Probably fairly remote, as long as they're not bad actors. But we still have to deal with the fact that our statute already adopts the federal definitions.
Thank you, Mr. Kaufman. Any additional questions or discussion? Go ahead, Representative Lynn. Oh, sorry, I'm going to go to Representative Greer.
Yeah,
go ahead, Representative Greer.
Yeah, Mr. Chairman, I was following along when I was offline. You did a pretty good Kurt Gowdy there for me, but the motion before the committee, you're saying is the motion is to have a $35,000 cap. Is that correct?
Yes, an aye would be for the $35,000 cap. A no would be no cap.
So the excuse me, Mr. Chairman, the $10,000 isn't in existing. It is not existing in Wyoming.
That is the current statute. So we have two options, and this is not an exhaustive list of options, right? Current statute is what you see online, page 4, lines 10 through 13, prior to any changes. So the issuer has not accepted more than $10,000, et cetera.
Right.
The proposal that Mr. Kaufman brought the last time we met was for the 35,000, but then in our discussion, we asked that it be drafted both ways, with 35,000 or without a limit. So we have those options before us, but again, not an exhaustive list.
Okay, I'm sorry, Mr. Chair, I was trying to understand how that would be, because I would have figured a no vote would be existing statute, but you're telling me it's a binary choice here.
The motion, Representative Greer, was to add in this alternative language to the bill.
But then, Mr. Chairman, if I vote no, I would be voting for $10,000.
You would not, because later in the bill is a repealer.
Okay, thank you.
Yep. All right, and I saw Representative Lindholm. I believe you had your hand up also before we vote.
Yeah, thank you, Mr. Chairman. And I really respect the conversation that's been happening here, and I think there is merit in standing out and taking a stand on certain aspects. I do think that the reality is they're going to fall back on the federal position, just because that is a kinder, gentler way to those poor people and keeping them from their money. But also recognizing that 35,000 is considerably better. The motion is I enjoy this motion much more than other motions because both are good. But I'll still be voting no, because ultimately I don't think I should dictate what other people do with their own money.
Thank you, Representative. Further discussion? All right, I'm going to weigh in briefly as well. I 100% agree with Representative Lindholm on the principle, but I'm going to support the motion for 35,000 because I feel like our principle in that instance might actually hurt our industry and hurt their ability to use this tool. So while I wish we had the flexibility to eliminate it, which I fully agree with, Mr. Kaufman, he has experience directly in this realm. He's probably the only person with experience in this realm in the state. And I'm going to go with his instinct on it, that we're moving in the right direction. And I don't want to threaten our industry's ability to actually utilize this tool by going a little bit too far. I was comfortable with the 15 million last time on the other motion, but on this one, I can see where there'd be concern. So with that, I'm going to be an aye vote on the motion. Further discussion before we vote? With that, all those in favor of the motion to move to $35,000 limit, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8. I see 8 votes. Those opposed, raise your hand. I see 3 votes. That motion has passed 8-3. All right, so we've got 35,000 in the bill right now. Any further amendments on page 4? Seeing none, page 5. There was the request from the Secretary of State's office on line 13, page 5, to add after any purchaser and the Secretary of State. Would anybody be interested in making that motion on behalf of the Secretary of State's office? See a motion by Mr. Kaufman, a second by Senator Dockstader. Any discussion on the motion? Seeing none, all those in favor signify by raising your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9. I see 9 ayes. Those opposed, raise your hand. I see 2 noes, 9-2. That motion has carried. Mr. Hopkinson, go ahead.
Thank you, Mr. Chairman. Just to clarify, I believe the intention is to put that on line 10, not on line 13, just based on the language that the Secretary of State's office used. There is no purchaser in line 13.
I don't have anything on line 10. Which draft are you
Maybe
looking
I'm
at?
looking at an old draft version.
I'm on 0.4.
Mr. Chairman?
Go ahead, Representative.
Well, I did not hear the testimony of the Secretary of State's office. That makes sense. What they're asking is that to be put online and then provided to the Secretary of State's office. When it's on line 13, that means every time a purchaser makes a request, it'd have to go to Secretary of State's office, if I read that right. So it makes more sense it goes in the section above without having heard the testimony.
Are we all looking at 0.4?
Mr. Chairman?
Go ahead.
I think, well, I don't know. Again, I wasn't online, but I think they're just talking about at the end of that section above.
Well, their request, as I understood it, was page 5, line 13, after to any purchaser or the Secretary of State on request, so that the Secretary of State could ask for a written copy of information if they so desired. I've got that on line 13, which is paragraph Romanet 3.
Mr. Chairman, I believe that's correct.
Mr. Hopkinson?
Mr. Chairman, the copy I have has that on line 10, so we're talking about the same line. I'm just not sure. I'm trying to figure out why, because I'm looking at point 4. I'm not sure why my line numbering is different, but
Interesting.
Paragraph 3 is where it would go.
Yeah. Okay. I'm looking at the online copy that's posted. I don't know why there's a discrepancy. And Representative Greer, I don't know which paragraph were you looking at, Representative Greer?
No, I'll withdraw my comments. Again, I didn't hear the testimony. I just was trying to help move us along.
Gotcha. Okay. Thank you. All right. Well, Mr. Hopkinson, I think you know where it's supposed to be at. It's on paragraph 3. So we'll get that sorted. Any further discussion on that before we move on? Okay. Seeing none, that was page 5. We are now on page 6. Further discussion, seeing none, back on the bill itself. Any discussion on the bill? All right. Seeing none. All right, here's the question. We have amendments in place. It seems like, and we had a motion on the bill. At this point in time, we'll probably go to a roll call vote unless anybody feels that there needs to be more work, which I'm not averse to, but I think we're done with this one. So I'm going to leave it open for that discussion before we move on. Does anyone want to intervene? No. Okay. With that, roll call vote, Mr. Hopkinson. So this will only be legislators based on the structure of the select committee, and it will be approved and a select committee bill as we're voting right now. So Mr. Hopkinson, call the roll.
Mr. Chairman, this is a roll call vote on 21 LSO 156 version 4 as amended. Senator Dockstader.
Aye.
Senator Driscoll.
Aye.
Senator Nethercott.
Aye.
Representative Greer.
Aye.
Representative Lindholm.
Aye.
Representative Yin.
Aye.
Co-Chairman Olson.
He said aye.
Co-Chairman Rothfuss.
Aye.
That passes, Mr. Chairman.
All right. Thank you very much. Thanks, everybody. With that, we're going to take a break for, let's try and do 10 minutes if we can, get back at 3:40. Again, break until 3:40. Mute your video, mute your sound. See you shortly. All right, so community, let's come back together. If you're out there, please join. All right, so community, let's come back together. If you're out there. Somebody's got their YouTube on, so let's kill the YouTubes. Okay. And Scott, Jody, and Dean, I'm going to ask you guys to mute your video until we get to the comment section. So we'll bring you all on in just a couple of minutes. We've got you on the agenda. Thank you. All right, who are we missing? Just a couple more. Get ready to go. All right, well, let's get back going and we'll have the others join shortly. I think we've got a quorum here. So up next on the agenda, and our last item for the day is public benefit corporations. We've got some draft legislation, and we talked about this a little bit at the last meeting. We're going to go through the draft legislation after a little bit, but we'll also hear from M-Shift shortly. But before we get into that, I'd ask Mr. Kaufman perhaps to kind of, there's a lot of people that'll be watching this and listening that haven't had an opportunity to hear our previous discussion and testimony. So if you want to give a quick overview about what we're looking at here through this legislation and on this topic, I think that would be handy.
Yeah, Mr. Chairman, thank you very much. So the impetus and the idea behind this bill is relatively straightforward. For those that aren't familiar, a traditional corporation operating under Wyoming law, but it's generally consistent with all other states. The directors of a corporation have a primary fiduciary obligation to the shareholders. And so in the event of a corporation that wants to take any sort of benevolent, charitable, or other action that considers other stakeholders outside of the shareholders, they can actually put themselves at risk of legal liability for doing so. And there is a long-standing, well-developed body of case law in this country in that regard. And so there's been a modern trend amongst states to adopt something called a public benefit corporation. And the idea is simply the inverse of what I just described. That is, it permits corporations to form and opt to be a public benefit corporation for the purpose of allowing their directors to consider and take into account the interests of stakeholders that are non-shareholders. And they can do so in a manner that protects them from liability just by virtue of the fact of taking that into account. And so, forgive me, Ms. Co-Chair, I forgot the exact number, but I'd researched it to some extent. I think 30 some other states have adopted some form of a public benefit corporation. This legislation that we have in front of us is modeled after Delaware's public benefit corporation. Most every jurisdiction that considers itself a competitor in terms of being a favorite corporate jurisdiction has some form of this. And we're seeing these entities being used for a lot of purposes. There's just simply a lot of instances where these entities want to be for profit, So nonprofit is not an option, but they just want to simply have the ability to take into account other stakeholder interests. And so this has broader implication in my mind, much broader implication than just, blockchain crypto companies, but it certainly is one of those as well. There's a lot of financial innovation and a lot of corporate innovation surrounding the use of this entity structure to do some very unique things. Mr. Chairman, you and I had a interesting discussion about this very thing and how, in combination with things like crowdfunding and equity raising, people are using these entities to do very unique, for-profit ventures that also have a community or a public benefit in mind. So that's the general overview of the bill. I don't know if you were looking for me to go specifically through the bill, but that's the impetus behind it.
Nope, that's perfect. That's what I was looking for. And we'll get to the bill after we take some of our testimony. We'll hear from our scheduled folks from M-Shift, and then we'll probably take a look at the bill and read through the bill, have Mr. Hopkinson walk us through it, so that we have that on the table and kind of have a look at it. And then we'll look for some other public testimony so that they have an opportunity to weigh in on the bill as well, I think. Any questions for Mr. Kaufman before we walk down the path here? All right. Now go ahead, Representative Lindholm.
Thank you, Mr. Chairman. Sorry about that. Mr. Kaufman, are there notable examples of public benefit corporations, and if so, who?
Go ahead, Mr. Kaufman.
Yeah, great question. There's a lot of notable examples. One such example that many of you may have heard of is Kickstarter. Kickstarter is an online platform where you can, it's crowdfunding, but it's product-based crowdfunding where you can basically pre-sell goods or services for your startup and raise money in that way. Again, Kickstarter's for-profit venture. They have investors, they have shareholders, but one of their missions is to help low-income people start companies. And so in that vein, they have opted to allow themselves to experience slightly reduced profits so that they can channel some money into those types of things. Another really interesting one is a very large flour company on the East Coast. It's called King Flour, and they're a public benefit corporation in Massachusetts for the reason of they're willing to pay higher prices for their wheat because they want to buy U.S. wheat. They don't want to buy overseas commodities. And they also have some other charitable and benevolent things that they do. But again, an example of a company that has sort of making a stand and using the public benefit to allow them to do some things that the traditional doesn't. So those are a couple of examples right there.
Excellent. Thank you, Mr. Kaufman. Follow up, Representative Lindholm, you good? All right. Additional questions or discussion before we go to our guests? All right, seeing none, we have M-Shift before us advocating for a public benefit corporation, and we appreciate you joining us once again. Mr. Mueller, you've been a participant certainly with our task force meetings for a number of years now and have worked with us on a number of topics. We were just discussing earlier today how important the community engagement and stakeholder engagement has been to our process and our product. So thank you for your participation and for continuing your support. Mr. Schaefer, you as well. You've been with us on a number of occasions, and Jody has has been with us for a lot of years on a lot of different topics. So welcome to all three of you. And I don't know who's planning on starting it, but the floor is yours, and we appreciate your participation.
Thank you, Chairman. Really appreciate the opportunity to speak on this. And as you said, we are absolutely in favor of this legislation. I'll leave it to Jody to talk a little bit about the detail. But one thing I did want to put forth was just listening to the discussion in the last session as you were talking about crowdfunding. And it really resonates. It brings it home to me how Wyoming is right at the stage of establishing itself as the financial center for the new millennium. Mr. Pierce is right. Okay, the actions that you're taking today, including this for public benefit corporations, are defining the capabilities of the state to be able to punch above its weight. So I really see that this jurisdiction is going to be perceived in the same mindset as, let's say, Singapore or Hong Kong, but some jurisdiction that really leads the world. Jody, why don't I hand it off to you? We're completely in favor of this legislation. There's just a couple of small tweaks that we would like to see. So, Jody.
Excellent. Thanks, Ms. Levin. Floor is yours.
Thank you, Mr. Chairman. Jody Levin, appearing on behalf of M-Shift today. As Mr. Moeller indicated, M-Shift is in support of this legislation. I do have one amendment that M-Shift would appreciate the committee's consideration on, but before I go there, M-Shift is very mindful. I'm certainly very mindful of the comments at your August committee hearing, where some members of this committee really questioned whether it was appropriate for the select committee to address this type of bill, or if it should be addressed through the traditional committee of consideration and jurisdiction, which would be joint corporations. And so we just wanted to offer that this is not something that M-Shift needs immediately in order to file its application through the sandbox with the Secretary of State's office. There's certainly plenty of excitement and enthusiasm about the pilot, and we would love to capitalize on that momentum and kind of keep this moving forward. But it's more important to M-Shift that the partnership with the state of Wyoming be on the appropriate footing from the beginning. So if it is, remains a concern with this committee, or at least members of this committee, that this should go through a full interim before joint corporations, I just wanted to offer that M-Shift will work through those channels and will take this issue forward to the co-chairs of joint corporation and to management council as a 2021 interim study. If the committee wants, I can certainly walk through the one amendment that M-Shift believes is important, but I did want to be mindful of the conversation, not just in August, but even this morning before the select committee.
Thank you, Ms. Levin. And, this is a discussion that we'll have, whether we need to continue our work here or whether we want it to go to corporations committee. I would like to hear the proposal and the full testimony, and then we'll sort of we'll visit that afterwards, I think, and decide whether we want to work it. But yeah, please proceed and let us know what tweaks or changes you'd like to see relative to this draft. And we obviously haven't walked through it yet, and we'll do that in a little bit, but let us know what your thoughts are.
Thank you, Mr. Chairman. So the one amendment M-Shift would ask the committee to consider is on page 10, line 6. It's at the beginning of the sentence. And we would request that you add a phrase that says, unless otherwise agreed by the shareholders. And why this becomes important to M-Shift. M-Shift knows that as a disruptor technology and platform, there are entities who are going to work against its success and adoption of this technology. So by adding in an alternative enforcement mechanism, and this will have to be disclosed in the articles of incorporation and the bylaws, it allows M-Shift to potentially limit the possibility of legal action by entities who would seek to obtain a majority share of the company with the intent of something that is actually against the company's ultimate interest. Now, this is a really exciting pilot, and it holds amazing potential for both consumers and merchants, but it really is taking on the mammoth in the industry when you look at payments and who will not like this type of technology and this type of platform. So by giving an alternative enforcement mechanism, M-Shift really is trying to seek what it believes is going to be the inevitable, and that is an entity that's going to try to, no pun intended here, but disrupt the company. And that's the one amendment that M-Shift would request consideration of.
Thank you, Ms. Levin. Talk us through, and we haven't walked through maybe I'll ask you the question of how it influences it when we get through the legislation. That might be more appropriate so that we have it in context. So I'll hold off on my question. Any questions for Ms. Levin at this time regarding that discussion? Any other questions for M-Shift at this time? And recall, we heard extensively from him last week as well. So we have some, last meeting, so we have some context. Representative Lindholm, go ahead.
Thank you, Mr. Chairman. I just wanted to mention that it is 4:55 in the morning where Mr. Moeller is at. So appreciate his testimony. That's can't be a lot of fun. And also, Mr. Chairman, I did want to declare right from the get-go, so that the whole committee knows and the public knows that I am contracted with a company that could possibly use this legislation. So I will be a conflict on the vote on this bill.
Thank you, Representative Lindholm. We'll note that. Any further discussion or questions at this time? All right. Scott or Ms. Levin or Dean, anything else that you'd like to add at this time? We may have more questions and we'll keep you around, but anything else for now?
Not so much right now, Chairman. Just keep doing the good work you're doing.
Indeed.
Great. Thank you. All right. Yeah, stick around as we work through this, and I think we'll have some more public comment as well. But so on the topic of the Corporations Committee and Representative Lindholm having just conflicted himself out, I'm still going to talk to him as the chairman of the committee in terms of process more than in terms of supporting the legislation. And let's have a preliminary discussion here about process and whether we should be working this legislation through our committee here, or whether we should be looking to the Corporations Committee. And I see that Co-Chairman Olson wants to weigh in real quick. So go ahead, Co-Chairman.
Yeah, thank you, Mr. Chairman. I think I should weigh in because I think I was, if not the first one, maybe the only voice that thought maybe this legislation should go to corporations. I'm not convinced of that anymore. I think that this is a perfect, as I learn more about it and I watch it unfold, I think that this committee is definitely a vehicle for it. Could be multiple committees that are vehicles for the legislation, whether it's corporations or here. I don't have a preference honestly anymore. So I want to make that really open and clear to the committee that if you want to pursue this, you can. So that's my opinion, Mr. Chairman.
Thank you, Co-Chairman Olson. And let's go to Representative Lindholm now. Thoughts?
Yeah, thank you, Mr. Chairman. While I am declaring conflict on my vote, I still plan on advocating for the legislation. I still plan on testifying on it because I've done a lot of reading on it. Obviously, not as much as Mr. Kaufman. But so when it comes down to process, the reality, Mr. Chairman, is this piece of legislation is going to go to corporations no matter what. It just is, because this group of people can't sit during legislative session, so it has to be assigned to corporations or another standing committee. I fully suspect that it will go to corporations, so I think the process is still there. It's much like a lot of the other bills that our task force has seen in the past, where it ends up going to minerals or corporations or another committee for final sponsorship. The biggest difference here is this is a select committee that can sponsor its own legislation. So it's still going to, effectively, it still has to go to corporations once in session. We're just skipping that one step. And so I think that's ultimately it, Mr. Chairman. I personally, as the chairman of House Corporations, I don't see an issue with it because it wasn't assigned to the Corporations Committee as a management council topic. And we may be the last committee that's mindful of management council topics, although we do skate the line a little bit. With that, Mr. Chairman, I don't see an issue, but that's my opinion.
Excellent. One quick question there, and then I'll go to Majority Leader Dockstader. In terms of process, one of the other things that Ms. Levin noted, which is always a good point, is whether we have sufficient complexity to need an interim to work the bill, or whether we're comfortable that the product is going to be in good shape going through the process we have. And I'd be interested to know your thoughts on that. And I also realize, cognizant of the fact that when we get things to the Minerals Committee, for example, we frequently just say, hey, this isn't ready yet during session. Not that it's a bad idea, but that it needs more work, and then we kick it to the interim. So we know that can certainly be an outcome. But what are your thoughts on doing this through our committee now and then referring it in session to the Corporations Committee, as opposed to getting it assigned as an interim topic?
No, Mr. Chairman, it's a great point, and it's something that I look at this committee, and you think about committees and having the ability to prepare legislation or fully understand and vet the legislation. I'm seeing chairman, appropriations member, management council. So
we're not a bad little committee.
No, I've got a lot of confidence in this Chairman, as far as understanding the process. That being said, for my House members, you'll remember I was the chairman of this blockchain task force, and one of the bills last year during introduction vote, I stood up as a no vote and got, I think it was 56 other members of the House to stand with me to kill our own bill because it wasn't ready. We couldn't figure it out, and it was one of those things we were still trying to work through. So I think if that comes down to it, where we find a hole in this deal, I have full confidence that either you or Co-Chairman Olson will bring out your axe.
Okay.
But I'm always for moving the ball. You know that, Mr. Chairman.
Absolutely. Thank you, Representative Linton. Majority Leader Dockstetter.
Thank you, Mr. Chairman. We should probably move that ball, but we should probably do a little heads up. I'm not sure how the committees are going to unfold on both sides, but probably most of the people will be staying there. We should give them a heads up and let this committee, with their expertise in place, tee it up and get it ready.
Yep, that sounds great, and I think that's great advice, Majority Leader Dockstetter. Let's make sure that if we do proceed on this, which I think the committee is generally supportive of it, that we immediately send it over to Corporations Committee members so that they're beginning to prepare for it and know what we're up to. Maybe we'll do that through a motion, send a letter and a copy of it from the committee to the Corporations Committee to make sure that they're aware of what we're working on and working lockstep with us. Thank you, Mr. Majority Leader. Additional discussion on this topic. I think the next step then that I'd like to take is that I'd like to walk through the bill and get discussion. Christopher, I'm gonna walk through the bill first, unless you're specifically on this point of process. I want to walk through the bill so everyone knows what we're talking about, and then we'll get to public comment. So with that, unless we have anything before we walk through the bill, I'd invite Mr. Hopkinson to join us and walk through the bill. And then before we get to public comment, I'm also going to ask Mr. Kaufman, after we walk through the bill, he's got some prepared amendments to discuss. So I want to raise all of these issues so that they're all on the table and transparent, and then we'll get back to public comment and take some input on it. Also hear from MShift if they have any concerns. So with that, Mr. Hopkinson, what bill draft are you working from?
Mr. Chairman, I reprinted my copy, so my lining should line up with everyone else's. I'm looking at 21 LSO 160, working draft 0.4, for-profit public benefit corporations. On the first page, you'll see a staff comment that does point out this is based on Delaware law. That's where the vast majority of this comes from, with some tweaks, of course, to incorporate it into Wyoming law. On page 2, you'll see that what this does, it creates a new article in the Wyoming Business Corporations Act, and is the Wyoming Statute 1716. In that chapter, it creates 1901 through 1909. On that first or second page there, we've got the definitions. It outlines that a for-profit public benefit corporation, and I just wanted to mention the reason we see that for-profit public benefit corporations there is Wyoming law already has what's called a public benefit corporations under the Nonprofit Corporations Act, whereas Delaware and other places don't seem to have that particular definition. So you'll see clarifying language in here specifying that this does not apply to that public benefit corporation, and to distinguish that, that's why we frankly added the for-profit to the front of that. So you'll see a for-profit public benefit corporation is a for-profit corporation organized and under and subject to the requirements of this chapter. It's intended to produce a public benefit and to operate in a responsible and sustainable manner. It shall be managed in a manner that balances the pecuniary interests of the stockholders, the best interests of those material affected by the corporation's conduct, and the public benefits identified in its articles of corporation. And that's kind of what the for-profit public benefit corporation is, and has been described. It creates kind of this balancing requirement. As I mentioned, the end there specifically does not apply to the public benefit corporation and the nonprofit statute. On page 3, paragraph 2 defines public benefit, which is essentially that it provides a positive or reduction of a negative effect in a variety of categories. Paragraph 3, public benefit provisions, that's simply the provision provided in the articles of incorporation for that public benefit. Section 1716-1902 specifies the applicability and provides that the article applies to all for-profit public benefit corporations, and that it's subject to, in all respects, to the provisions of this chapter. In other words, to the Wyoming Business Corporation Act. It's subject to all those provisions, except to the extent that this article or this bill imposes additional or different requirements. On page 4, section 1716-1903 provides some additions to the articles of incorporation to be required. Paragraph 1 specifies that the company shall identify one or more public benefits to be promoted by the corporation. And paragraph 2 specifies that it shall state that it is a for-profit public benefit corporation. Subsection B, and this, again, this is Delaware law, so this certainly, if the committee doesn't like this designation of the abbreviation PBC, that's certainly up to the committee there to decide. But it provides that a for-profit public benefit corporation can contain the words public benefit corporation or that abbreviation PBC. It provides that if the name does not contain such language, that the corporation shall, prior to issuing unissued shares of stock, provide notice to any person whom the stock is issued or who acquires the treasury shares that it is a for-profit public benefit corporation. That notice on page 5 at the top there, that notice need not be provided if the issuance or disposal is pursuant to an offering registered under the Securities Act of 1933, or if at the time of the issuance or disposal, the corporation has a class of securities that is registered under the Securities Exchange Act of 1934. Section 1716-1904, line 8 on page 5, provides that a nonprofit non-stock corporation shall not be a constituent corporation to any merger or consolidation with a for-profit public benefit corporation. 1716-1905 addresses stock certificates and the notices regarding uncertificated stock, and provides that any stock certificate issued by a for-profit public benefit corporation shall note conspicuously that the corporation is a for-profit public benefit corporation, and that any notice given by a for-profit public benefit corporation shall state conspicuously that the corporation is a for-profit public benefit corporation. On page 6, in 1716-1906 addresses the duties of the directors. Subsection A provides that the board of directors shall manage or direct the business in a manner that balances the pecuniary interests of the stockholders, the best interests of those materially affected by the corporation's conduct, and the public benefits identified in its articles of incorporation. And so that subsection, I think, is at the core of what this public benefits corporation is, and that's the requirement there for the directors to balance those interests. Subsection B provides that a director shall not, by virtue of the public benefit provisions, have any duty to any person on account of any interest of the person in the public benefit. So that provides some limitation there on the duty of the director. They don't have to have any, they don't have a particular duty to someone who just simply has an interest in the public benefit of the corporation. It also provides there that with respect to any decision implicating the balance requirements, that if the director's decision is both informed and disinterested and not such that no person of ordinary sound judgment would approve, then it's not found to be that even if they have a material interest, that's not an issue. Subsection C provides that a director's ownership of interest or stock shall not alone create a conflict of interest, except to the extent that the ownership of interest would create a conflict if the corporation were not a for-profit public benefit corporation. It further provides that in the absence of a conflict of interest, no failure to satisfy the balancing requirement shall constitute an act or omission not in good faith or breach of the duty of loyalty, unless the articles of incorporation provide. On the bottom of page 7, section 17, 16, 1907, well, and actually, excuse me, subsection A provides that a for-profit public benefit corporation shall include in every notice of a meeting of stockholders a statement to the effect that it is a for-profit public benefit corporation. Subsection B provides that no less than biennially that the corporation shall provide its stockholders with a statement as to the corporation's promotion of the public benefits identified in the articles of incorporation and the best interests of those material affected. The statement shall include paragraph 1, the objectives of the board of directors that they've established to promote that public benefit. Paragraph 2, that the standards of the board of directors, what standards they've adopted to measure the progress. Paragraph 3, it shall include objective factual information based on those standards regarding the corporation's success in meeting their objectives. And paragraph 4, which will provide an assessment of the corporation's success in meeting the objectives and promoting the public benefits and interests. Subsection C requires that the articles of incorporation may require that the corporation do one or more of the following. Paragraph 1, that they provide the statement described previously more frequently than biennially. That in paragraph 2, that they make the statement described in subsection B available to the public. Or in paragraph 3, that they use a third-party standard in connection with or attain to a periodic third-party certification addressing the corporation's promotion of the public benefits or interests, or of those material affected thereby. Section 17, 16, 1908 addresses the enforcement of those balancing requirements and simply provides that any action to enforce the balancing requirement shall not be brought unless the plaintiffs, either individually or collectively, own, as of the date instituting the proceeding, they own at least 2% of the corporation's outstanding shares, or if they are traded on a national securities exchange, the lesser of the 2%, or at least $2 million as of the date the action is instituted. In 17, 16, 1909, provides that this article will not affect a statute or rule of law applicable to a corporation that is not a for-profit public benefit corporation, except as otherwise provided in section 1716 1904, which we've seen previously. Section 2 of the bill provides some amendments to existing statutes, primarily conforming amendments. The first one there amends 1716-140 and provides that that act includes these new this new article, and that again is the Wyoming Business Corporation Act. It amends 1718-102A, the Wyoming Management Stability Act, to also include the new article. And then it would also amend 4029-103, the Financial Technology Sandbox Waiver. So this again would be a policy decision for the committee, but it would amend in paragraph A4, it would amend that statute to include the public benefits corporation, so that those could also be included in the financial technology sandbox. Provides in section 3 for an effective date of July 1st, 2021. And with that, I would stand for any questions on the bill.
Excellent. Thank you, Mr. Hopkinson. Appreciate going through the legislation. Committee questions on the legislation? Any questions for Mr. Hopkinson? All right, seeing none at this time. Let's, and I guess before I turn it over to Mr. Kaufman to discuss his amendments, any other general thoughts or discussion that the committee wants to have at this point on the legislation before we get to some proposed discussion of the amendments? All right, seeing none. Mr. Kaufman, you have a few amendments and suggestions, and those have been circulated to the select committee, so you can see a digital copy of it. You should all have that in your email from a few minutes ago. With that, Mr. Kaufman, the floor is yours. Do you want to discuss with us some of your suggestions here?
Sure, Mr. Chairman, do you want me to go through all of them? There's only 5, but
yeah, please do. Just kind of step through, and we'll try and discuss each of them if there are any questions between them.
So I'm generally, my first comment is, as I mentioned before, this legislation is modeled after the Delaware Act. I think it's very good. It's worth noting that there have been a couple of recent changes in the Delaware Act, which this draft captures. So this draft is pretty consistent with the most recent changes of Delaware. There's just a couple of minor things that I think we need to tweak to make it consistent with our own corporate act more than anything. The first one is on page 3, 1716-1902. I discussed this bill with the Secretary of State's office, and we both agreed that we need to have some indicator in this language that any corporation, and by any corporation I mean a regular for-profit corporation or a nonprofit, can elect to convert, and that just doesn't exist anywhere in the current statute. So the proposed language would just be on line 18 to insert if, and then the words any type of corporation elects to become, comma, or converts to a for-profit public benefit corporation. We just thought that created the clarification that any of those corporations could convert. Obviously, that would have to be reflected on their articles and filings, etc. But so subtle change, but an important one. That was the first one.
All right, committee, on that one, the one question I have briefly, Mr. Kaufman, is you said if any type of corporation. I think the language we has if a corporation. Do you see advantage to that alternative language of any type of, as opposed to if a corporation?
Well, the Secretary of State's office brought up a good point. We just wanted to make it clear that it included nonprofits as well. And so this was my attempt to capture as inclusive of a swath as we could, because we do have, again, we have close corporations, we have professional corporations, we do have some different types of corporations. So this was an attempt to be all inclusive of all of them.
Okay, thanks. Any questions, committee, on this first suggested change? Seeing none, go ahead, Mr. Kaufman.
The next one was on 17/16/1903, which is on page 4. And the simple concern here, and I think this was just a difference in the construction of the Delaware Act versus ours, but this draft didn't actually include the requirements for these entities to have a registered agent and otherwise comply with all the filing requirements. So the suggestion here is just a simple addition in paragraph A, that we would insert this language in addition to any requirements set forth in 17/16/202. That statutory section is the section that sets forth what corporations have to include in their articles when they file, including something like a registered agent.
Okay, any thoughts on that? Questions? Seeing none, thank you. Please continue.
The next one was 17/16/1904, which is on page 5. And this suggestion was just to simply remove the word non-stock. In our act, we don't really refer to nonprofits as non-stock corporations. That's, I think, a carryover from the Delaware Act. So I literally think we could just delete the word non-stock.
Okay, any questions on that? Seeing none, please continue.
The next one was 17/16/1907, which is on page 8. And this was in line 10. And this was where it mentioned a for-profit public benefit corporation shall no less than biennially provide stockholders with a statement. There's been much debate about this around a lot of states. I think a lot of states are moving away from biennial reporting. It's just cumbersome. And so the suggestion here was just to go with annually instead of biennially.
Okay, discussion on that. Was there any motivation, Mr. Kaufman, for why the biennially has been done in this situation? Justification?
Yeah, good question, Mr. Chair. From what I've gathered in my research, a few of the first states that adopted public benefit, that seemed to be a trade-off for them, that people were still at that point in time unsure of the utility of the entity, and so they wanted to increase the reporting. Over time, I think people have realized that's a bit cumbersome, and again, could be a disincentive for people to use this corporate form. That doesn't exist, obviously, necessarily in the same way for corporations. So annual is more in line with an annual shareholders meeting requirement, something like that.
Okay, so that effectively makes it consistent with the rest of our corporations would have an annual reporting requirement, and this would be similar to that. Do we have any others? Do we have any other non-annual reporting requirements for our corporations?
Not that I'm aware of, Mr. Chairman.
Okay, great. Questions?
And then the last one was 17/16/1908. And Ms. Levin already discussed this, and I discussed this previously with her, but so just real quickly for context, the purpose of this 17/16/1908 is simply to slightly raise the bar, since these companies are now allowed to take into account non-shareholder interests. Most states have adopted this standard where you slightly raise the bar for shareholders to bring a derivative action against the company, and so you set this minimum threshold of 2%. The question became, what if companies want to change that requirement, make it higher or make it lower? And that's again seems to be sort of a favored position amongst the business community. So the simple solution here was just a precursor to that sentence that says, unless otherwise agreed by the shareholders. So if the company wants to vary that standard by their own bylaws or shareholder rights agreement, that's fine, but this would be the default. So I think that change would accomplish that. And that's it, Mr. Chairman.
So walk through, I realize that's kind of trying to be protective of any hostile intentions or anything along those lines. So I guess the question I have on the last one, you see any scenarios in which that could kind of work in the opposite way, where if you have an opportunity to change this by shareholder, then you can work against the intent of the public benefit and end up being manipulated as a result of not having this protection, because unless otherwise agreed upon by the shareholders, would, I think, basically wipe out, it would wipe out the entire provision, so that basically the shareholders can opt out of this provision entirely is more or less what I'm reading. And is that too much? Is there any potential danger there?
So again, Mr. Chairman, if I'm understanding the question, currently a for-profit corporation, we don't have anything like this.
Right.
Right. So there's no minimum. Any shareholder has standing by virtue of being a shareholder to bring a derivative action. So this section, all it does is say, if you're going to bring a derivative action on the basis of that balancing act of those directors trying to balance the non-shareholder interests, we're at least going to create a minimum threshold that you have to have 2% ownership to bring that. Again, it sort of, in my mind, works in concert with something like a crowdfunding, where you might have a lot of very small shareholders. You mitigate to some extent the risk for that company in exchange for them having this public good or this public purpose. So obviously that has to be a pretty low bar, a low threshold, which this 2% accomplishes. But again, if a state wanted to waive that and allow anybody, that's more protective of the shareholder, as opposed to less protective. So I don't think that's a bad thing.
Okay. Thank you for the discussion on that point. All right. Seeing none, any further discussion on the bill before we open to public testimony? All right. I don't see any discussion. So I know we have Mr. Allen. Mr. Allen, please go ahead and join us by video if you can. And there you are. Welcome. Please once again introduce yourself. It's been a while since you've spoken, so in case somebody new is tuned in, please identify yourself. Welcome to the committee.
Thank you. So my name is Christopher Allen. I'm with Blockchain Commons, and I'm kind of speaking from multiple hats here, and I'm fairly, although I am not an attorney, I've dealt with a lot of different sides of this topic. So a credential I haven't given in the past is that I taught for 5 years in the Sustainable Business MBA program at Bainbridge Graduate Institute, which was considered one of the top sustainability and nonprofit teaching business schools in the United States, the first, in fact, in the United States, and was up there with Yale and Stanford and a number of other big things in the top 5 for the 10 years of its existence. It's now been merged with another school. So probably, just my students alone have done over 20 or 30 public benefit corporations. The school as a whole, probably hundreds. So I have a lot of, sort of experience from that side of it, but also from the blockchain commons and the DAO discussion side. There's a lot of discussion. A lot of these DAO organizations want to self-organize in interesting ways, et cetera. And this is where I get into the problem with the Delaware, and there are worse ones than the Delaware one in this area. So what is the benefit that the state is giving this corporation for making all of these restrictions? None. There's no charitable deduction. There's no tax benefit. There's none of that. What it is a legislative capture by a nonprofit called B Corp that has basically made all of these rules and has lobbied with a lot of money to make more of these rules in more and more states. Now, I'm not going to argue about corporations. I think there is some consensus, but not total consensus, that C Corps may have to give their shareholders first first cause or whatever. Although I will say there's debate on that, but there isn't really debate on LLCs. And so there's been a movement in Delaware, for instance, to do a benefit LLC when it's really clear. I apologize to on the previous discussion from Matt, where he said corporations. At best, it's C corps. LLCs explicitly were designed by Wyoming, who created them in the first place, to allow for a lot other considerations, family considerations, land considerations, etc. So I actually have written in our bylaws for Blockchain Commons under Wyoming law and as an LLC that we are a benefit corporation, because our bylaws say we can consider a variety of other things. We chose not to go for B Corp certification because they want to require a lot of sustainability requirements when we're doing benefit for a different cause, which is human rights and human dignity and those different types of things, which they don't really have in their thing. So a lot of their requirements and such in their legislation that they've lobbied for in these different states has these strong requirements and these annual things. There was a statement in there about that it needed third-party certification. You're not requiring your nonprofits to do third-party certification. So why, and they're getting tax benefits. So why are you requiring these parties to do so? So I very much am, in the vein of, if people want to bind themselves to a contract, that's great, but don't force them into a specific contract, especially with LLCs. What it is, it's a branding thing. It allows for some very legitimate, very good companies to basically brand that they're trying to do more than just bring profit to their shareholders. That includes like Ben & Jerry's, Method Detergent. A number of you have, I forget what the jacket company is, but one of the top outdoors jacket companies is a benefit corporation, whatever. And they've chosen to do the B Corp certification and share all that type of stuff. But I don't really think it needs to be, legislated that tight. And I'm very concerned about you basically doing something that means there's a reason I think that non-stock corporation thing in there that I think Matt was saying, why don't we pull that out? Well, LLCs are non-stock companies. They basically have percentages of ownership. So I don't want to basically be forced to not be able to call myself a benefit corporation, even though we have agreements and our stockholders can sue the corporation if we don't abide by those agreements. I want, those intentional choices to be there, but I feel like this really locks people into some really intense choices. I have put several different places an article, a really long article called Introducing the Totally Unnecessary Benefit LLC, which was published by the North Carolina Law Review. I put it in the YouTube and I also put it in the chat here. And I really encourage Matt and others to take a look at it. And if you're going to do a public benefit corporation or something like an L3C, which is a low profit benefit corporation, which the benefit to the L3C, I forget, L3C, is there are some nonprofits that say, if you're an L3C, we'll give you money, despite the fact you're not a nonprofit. That maybe doing an L3C might be a good idea in Wyoming, but don't lock people into, especially with LLCs, into legislative capture by B Corp and parties like that. That's it.
Thank you, Mr. Allen. Questions? Yeah, Representative Yin.
Thank you, Mr. Chairman. I actually, we actually have L3C statutes in Wyoming already, and the last meeting, I actually asked Mr. Kaufman about why couldn't, corporations just file under the L3C, and he actually gave me a good reason, because there are actual benefits to being a corporation over an LLC. But so I think ultimately it sounds like your concern is that you're worried that you're not allowed to call yourself a public benefit corporation anymore if we do this. And I'm not sure if that's the case based on this legislation. So maybe if someone else can, or if you know where in the legislation that it points out that you would not be able to continue doing that, because I don't think that it would force you to do anything differently, Mr. Allen.
Thank you, Representative Eden. Mr. Allen, you want to respond? Go ahead.
Yeah, I haven't seen the final detail on this. I didn't get a copy of the final document, but I've seen the Delaware ones and how they've been used. And so there's trademarks and other different types of things that people have been enforcing against parties that you know, and basically saying, hey, your state says that it's a requirement. So again, I'm more referring to my own students, a number of whom have actually withdrawn from being benefit corporations because they felt that they were restricted from doing what they really wanted to do by the more stringent requirements and expensive requirements of annual reporting and meeting their global sustainability report requirements and things of that nature, when maybe their public benefit wasn't environment. So go ahead.
Thank you, Mr. Allen. Yeah, let's go to Mr. Kaufman to kind of address some of those concerns. I don't know if those are in there. So Mr. Kaufman, go ahead.
Yeah, thank you, Mr. Chairman. So first, we do have the L3C already existing in our LLC statute. Not many people use it though, because it's defined in the definitions, but there's not really much built out within the Act to define how to use it. To the point of Mr. Allen, he's absolutely right. I mean, I think most legal scholars that I'm aware of agree that a public benefit style of LLC is unnecessary, and I'm not proposing that we do that. LLCs have a wholly different set of duties imposed upon the managers and members than corporate directors. And so I agree with him. I think that in terms of using an LLC, there's much more broad discretion for the entities to organize themselves that way. With respect to corporations, though, that's a whole different topic. And I want to make sure that everybody is clear, because there was some discussion of a couple of different concepts that have nothing to do with each other. A number of years ago, an organization called B Labs, which is a nationwide nonprofit, they went out on this endeavor, and Mr. Allen referred to this, to create something called the B Corp certification, benefit corporation certification. It has nothing to do with your legal structure, your legal filing, your legal organization as a public benefit corporation. The B Lab certification is just something that this entity touts as, hey, you can apply to us. If you meet our standards, we will give you this B Lab certificate. And some people have opted to do that because they think it's beneficial. They use it for marketing, whatever purpose. That is not in any way, shape, or form legally binding on any entity within the state. So I'm talking about something completely different from a B Lab certification. This is an actual entity selection that you can make within the state filing to be a public benefit corporation. And it codifies at law the option to be a public benefit corporation for all the reasons that we've been talking about. So I just want to make sure that we're clear on that. So by virtue of passing a bill like this, it would give existing corporations or nonprofit corporations the opportunity to either to convert to be a public benefit corporation, or new entities to be a public benefit corporation. If you're an LLC, it's not gonna affect you at all. And if you are an existing regular for-profit corporation, and you want to, include some benevolent purpose in your organizing documents, I mean, I would take the position that's up to you. Whether or not that holds up with legal scrutiny, if some shareholder is upset with you, I don't know what the outcome of that's going to be. But this is just simply codifying the option that those companies have to opt into that. I think that was all I had, Mr. Chairman.
Mr. Kaufman, one other point that Mr. Allen raised was along the lines of name infringements and trademarks and other considerations that were suggested were a problem with how these operate in Delaware. And
it wasn't Delaware, that paper. It was 20, but it was other states that did it.
Mr. Allen, hold on. Got to follow protocol here. So raise your hand a second. I'm sorry if I misspoke, but I'll continue the question, and I'll get back to you in a second. Anyway, Mr. Kaufman, do we have any concerns with the if as drafted this legislation would preclude somebody from saying they have a public benefit company? Are we labeling that as a term of art through this bill in any way that you see?
So, Mr. Chairman, again, I'm sure there's things out there that I'm not aware of, but the litigation that I'm aware of regarding trademark infringement is surrounding that B Corp certification that exists from that nonprofit that does the B Corp certification. And there are companies out there who have gone to their state, registered as a public benefit corporation, and then hold themselves out as having this B Corp certification because they confuse the issue. Again, those are two very different issues. I do think obviously companies can't go out and hold themselves as being this B Corp certified, but that's different from calling yourself a public benefit corporation as your legal structure under the filing.
Thank you, Mr. Kaufman. Mr. Allen, did you have follow-up thoughts there?
I apologize for that. I was just saying that I do hope, Mr. Kaufman, you get a chance to read that article, that law review article. You know, I think there can be a utility for having some type of C Corp public benefit style of things. I'm less convinced that just adopting Delaware's or somebody else's without kind of looking at what, you know, some of the stuff that this guy mentions and other people have mentioned and actual, you know, use cases that, you know, there was some early, you know, finger dipping by B Labs and such, you know, toward, again, you know, there is no state benefit. And, you know, you're not requiring nonprofits to do some of these types of things. Does the bar have to be quite as high as you've made it? I guess would be one of my, you know, key concerns. That's it.
Thank you, Mr. Allen. It brings up a good question, Mr. Kaufman, and I don't think there's any intent in us setting the bar through this legislation where it's higher than what we do with a C Corp. And I think the intent is to mirror identically C Corp and then have a provision that allows you to have a public benefit as part of your mission and then not have that public benefit cause conflict with shareholder interests where it would right now. Am I accurate in that, Mr. Kaufman? Do you see this language as being more or less restrictive in any other way than that one area with regard to statutory requirements for C Corps?
Yeah, thank you, Mr. Chairman. So the answer to that is no. Before we even brought this legislation forward, I and some others spent a significant amount of time researching what, you know, a whole lot of states have done in this respect. There are some states like Minnesota that have incredibly extensive statutes with respect to what's required. And then there are states like, you know, Delaware, Colorado, and many others that have something like this. And your point is well taken, Mr. Chairman. It is simply a corporation. It's a for-profit corporation. We're treating it like a corporation. All of its duties, obligations, and what it can and can't do is just like a corporation. The only thing that we are changing is the directors are permitted by law to take into account non-shareholder interests, which under current existing law, you can't do. And as a trade-off, the law just says, hey, if you're going to be a public benefit corporation, which could theoretically reduce, you know, the return on investor or shareholder profit, you got to tell them. You got to give them notice of that. You got to let them know on their share certificates. You got to take every opportunity you can to make sure that they're aware that you're a public benefit corporation. That's essentially the trade-off. Again, you know, the article, Mr. Allen, that you were referencing, that's all LLC analysis. I don't have any disagreement with the LLC analysis, but we're fundamentally talking about only corporations here, which is a very different legal analysis in this context.
Thank you, Mr. Kaufman. And Mr. Kaufman, when this was being drafted, was there any discussion about doing what we've kind of talked about doing with regard to you know, modifying an LLC where we kind of map back on some concepts for the DAO of having a modified corporation as a public benefit corporation, so that it relies on the corporate law, the C corporation law, standard corporation law, as the foundation, and then has a oh and by the way type of construct. And maybe that would help to clarify that. Was that discussed?
Mr. Chairman, that's essentially what this bill is.
Okay, you see it as that way. Okay, good. So we're just building off the corporation based on the structure. Perfect. Okay, thank you. Senator Dockstader, I saw your hand, but I could be wrong there. I don't know if you had anything there. Okay. All right. Additional questions for Mr. Kaufman at this point? Okay. Mary Beth, do we have any other public comment on this bill?
Mr. Chairman, I believe Dean Schaefer is in the meeting.
Yep, great. Dean wants to weigh in. Please join us, Dean. And if Ms. Levin or Mr. Moeller want to provide some thoughts on, and in particular, if they have any concerns, but I think they're all pretty straightforward with amendments proposed by Mr. Kaufman. That would be great to understand if you have any concerns there. Mr. Schaefer, the floor is yours. Welcome.
Thank you, Mr. Chairman. No concerns at all. We are, as Scott and Jody both mentioned at the top of the topic, we are very, very supportive of both the bill and the amendments offered by Ms. Levin and Mr. Kaufman. I'll also just simply add to that, I think that in prior testimony, I mentioned that I'm chair of the directors of the American World Money Initiative. And as chair of that board of directors, we'll be recruiting our directors from some of the largest and most influential companies in the country, and in fact, in some cases in the world. Those directors are going to want to be protected when they do the right thing. So when they make the decision to balance the interest of the shareholders and the constituents in Wyoming, the merchants in Wyoming, and as we roll out more broadly throughout the United States, they're going to want the protections that are offered by this bill. So we are, of course, fully supportive of it. And I thank you for the opportunity.
Thank you, Mr. Schaefer. Any questions for Mr. Schaefer? Seeing none. Mr. Mueller, I see that you had your hand up. Do you want to weigh in as well? Please identify yourself once again and welcome back.
Thank you, Chairman. Scott Mueller, CEO of MShift. Just one final comment I'd like to make. The public benefit corporation, it's another option that you have in order to establish a entity structure. And for us, this entity structure enables us to set some immutable principles that the company is going to act not solely in the shareholders' interest, but in the public interest. And those specific public interests are defined in the Articles of Incorporation. So that's what I see. It gives us the ability to really offer a true public service, and while at the same time balance the fiduciary needs of the shareholders. So that's all. I really like this structure, and I think it's going to be a benefit to Wyoming.
Excellent. Thank you, Mr. Mueller. Appreciate it. Anyone else? Ms. Levin, anything to add?
No, Mr. Chairman, thank you.
Thank you. Okay. Any further public comment before we close? Mary Beth, do we have anyone else? I think we're closed.
I don't have anyone else on my list.
All right, very good. Then with that, yep, go ahead, Representative Lindholm.
Yeah, I was curious if the Secretary of State's office is on standby, because this is obviously going to affect their office.
Oh, okay, that sounds good. Ms. Janes, are you still out there somewhere? I'm looking on the list to see if we see any Secretary of State. I don't right now.
Mr. Chairman, I believe the Secretary of State's office has left the meeting.
All right. I wonder if they're out there watching. Let's just give them like 10 or 15 seconds in case they're on YouTube. Ms. Janes, if you're lurking, please join. All right. Well, she's not rushing to join. We know that. Okay. And I'll just check back in with Mr. Kaufman. Mr. Kaufman, I I know that you were working closely with Secretary of State's office on the previous piece of legislation. What has been the nature of your interaction with the Secretary of State's office on this? Have they expressed any concerns?
Ms. Co-Chair, thanks. And I hate to speak for the Secretary of State's office, but no, we've been in communication about the draft. I think they were in agreement that the draft was good, subject to the amendments that I discussed with you. They also indicated to me, at least, that they didn't believe there would be any fiscal impact with this bill.
Absolutely. Thank you, Mr. Kaufman. And I believe, yep, I was just checking back in. I did get an email earlier from Deputy Wheeler specifically about this draft, and she expressed that she had worked with Mr. Kaufman on it and that their concerns were addressed, and particularly in light of some of the discussion about the amendments. So she also reiterated that in her belief, there'd be no fiscal impact to the bill, although realistically, I think we're all hoping for a substantial fiscal impact for the piece of legislation in that positive direction that we're always so eager to go. So hopefully this is a positive for the state. All right. Thank you, Mr. Kaufman. All right. Anything else? So public testimony is closed now. Committee, what's your pleasure?
Move the bill.
Move the bill.
We've got a motion by Representative Yin, and we've got a second by Ms. Long. All right. Let's open up for general discussion before we walk through the bill. Any thoughts on this? We had some members that I think had concerns at the previous meeting, and what I would really like to hear is if there are still any concerns and what would it take to address those. As a select committee and then as a task force before, we've really tried to move forward consensus legislation where everybody's pretty comfortable with it and willing to go and support it. So I really would like to understand concerns at this point and then see if there's anything we can do to address those concerns before we work the bill. So Representative Olson, Co-Chairman Olson, you expressed that it sounds like you're pretty comfortable with it at this point.
Mr. Chairman, I am comfortable with it. I will, however, put the committee on notice that I'll be voting conflict on the legislation. So I don't really have much to contribute to the conversation other than, I mean, I think it's a great idea, but that's my vote. So thank you, Mr. Chairman.
Absolutely. All right. So we're stacking up some conflicts here. Anyone else on the committee have any concerns at this point? Yeah, go ahead, Ms. Long.
Thank you, Mr. Chairman. The big concern with something like this generally is what's the definition of public interest, because that's very different for different people. And as it's drafted, it's very broad. So I'm going to support it, but the skeptic in me has a little voice in the back of my head saying, remember the eminent domain cases where public benefit was suddenly expanded in order to justify the taking of private property. It's not a direct analogy, but and here are all this is doing is conferring a benefit to from a liability reduction perspective. What is essentially doing is allowing a modified business judgment rule, as I understand it, where directors of corporations in a traditional for-profit corporation, C Corp, have to take one and only one thing into account, which is the interest of the shareholders. And once you start getting beyond that, you do start putting that liability shield of directors at play. We do not have a business judgment rule statute, to my knowledge, in Wyoming. It's not as clear cut, but this is designed to essentially allow for-profit businesses who do want to take something other than the interest of shareholders into account to take it into account. It doesn't therefore really harm the public in the way that expansion of eminent domain did. It doesn't take property rights away. And people voluntarily can invest in these or not based on what they know. The only other concern I'd have is just to make it very clear what type of corporation this is, and essentially make sure that investors understand the distinction. Thanks.
Thank you, Ms. Long. And I'll check back with Mr. Kaufman, but there's a good point there. And my interpretation is a public benefit is really whatever you define it as being. And you can disagree, but the corporation itself basically will set that in its bylaws. And if they deem it to be a public benefit through their their bylaws, then it is a public benefit in the eyes of that corporation. And I assume nobody has any say in telling them whether it is or isn't a public benefit. That's my interpretation. Is that accurate, Mr. Kaufman?
Yeah, Mr. Chairman, yes, that is correct. And Ms. Long is right. The definition of public benefit is very broad. The difference here is we're not talking about the public benefit of the state. We're talking about public benefit of an entity, a private entity that is doing something. And so, yeah, it is intended to be pretty broad so that their idea of public interest could be a lot of different things.
Mr. Kaufman, has there been any challenges or anything else along those lines with other public benefit corporations, for-profit public benefit corporations around the country, where someone has said, hey, we don't like your purpose, we don't think it's a public benefit, or is there any ground for challenge along those lines, or is their own internal interpretation always going to stand?
So again, Mr. Chairman, I can't obviously speak to everything out there because I have done research on that issue. The cases that I have found typically involve, minority shareholders who, for one reason or another, disagree, with the actions of the company for various reasons. No different than a private for-profit corporation. And so this act preserves, just like it would in a regular for-profit corporation, the ability of that shareholder to dissent, to file a derivative action if they meet the threshold, or to otherwise, try to get out of the corporation. So most of the litigation that I have read in Delaware and other states has been on that issue more than any other.
Great. Thank you, Mr. Kaufman. And it seems to me that that's appropriate, where it shouldn't necessarily be the business. It shouldn't, I'll just say that without necessarily, shouldn't be the business of the state to provide motivations to corporations and tell them what they should and shouldn't be using as their objectives. I think that would be overstepping our bounds, certainly. All right. Any additional thoughts? Okay, Representative Greer.
Yeah, I'm not going to support this bill, Mr. Chairman. And someone have to tell me I'm being overly paranoid, but the practice of sue and settle. So now what we're going to do is create an entity wherein shareholders can profit from that. At least if it's a charitable organization, the funds have to be accounted for and used to acquire additional lands or access or do something for the greater good. And I could see this opening a door wherein shareholders could profit from that type of practice. And that, I just think you're opening up Pandora's box. I think Ms. Long said it very well, is what creative group can be out there, and what purpose are we not thinking about? What are the unintended consequences from this? And so I don't see me ever supporting this.
Thank you, Representative Greer. I appreciate that discussion. Mr. Kaufman, go ahead.
Mr. Chairman, and I'm by no means want to go head to head with Representative Greer. I just wanted to share with the committee a couple of examples of companies that I have spoken to out there that have looked at this entity type as an option if it was available in Wyoming. One of which you all heard testimony from at our last meeting, and that was a company based out of Laramie that has developed software for the purpose of fighting human trafficking. And that software is currently owned by a nonprofit corporation, but because of a lot of the limitations of a nonprofit corporation, particularly in growth, taking on new money, they want to be a for-profit entity, but they don't want to solely be a for-profit entity because they want to continue in their mission. Mr. Chairman, you and I spoke about an example of there are people out there that have used models to put together benefit corporations to purchase local newspapers and crowdfund it, because the benefit is we want to keep this local news stream alive, even if it means we operate it at a loss or operate it at a marginal loss. There are other companies that are looking at this for public broadband access. And Representative Greer, I have an example I could use that's near and dear to both of our hearts, but you could imagine a telecom company saying, look, we obviously need to operate in a for-profit manner, but we might make some decisions for the public good or the public benefit that we would spend money on, broadband access or fiber expansion or whatever the case may be, that might technically be a violation of our director duties to the shareholders, but we could do that for a public good. So those are the types of examples that I have in my mind. I have no doubt there are examples out there of nefarious purposes and ways that this could be this misused, but I don't see that risk being any greater than a traditional corporation.
Thank you, Mr. Kaufman. That's my question also to Representative Greer is, I don't see what's new about this that would enable a sue and settle approach where, I mean, it's already done. If it's profitable, which I think was the intimation, then heck, that's in the interest of your shareholders. If it's profitable, it's actually the circumstance where it might not be directly profitable, but you'd be doing it for some structured public benefit. So I guess I'm just not seeing the case study, the tangible example where this would be enabling of some nefarious purpose that can't already be accomplished. I mean, honestly, corporations are pretty good at doing dodgy and nefarious things if that's their objective. They can do that because it's often in the shareholders' interests and making money. But with this circumstance, the idea is that you'd basically be saying, all right, well, you can have a secondary purpose. So, Representative Greer, I just want to understand better, I think, what circumstances or examples would be enabled by this that aren't already enabled in Wyoming statute.
That's first of all, if your purpose is a public purpose, okay, we have that statutes and those statutes are in place. If your purpose as a corporation is to have a more benevolent purpose behind what you're doing, for the example that Mr. Kaufman and I are very familiar with, you can look at long-term planning, long-term growth, and that can be part of those decisions that fall under business judgment rule. Simple fact is, I'm not going to sit here and argue for 2.5 hours, but I'm just telling you, you're not going to get my consensus vote on this.
Okay.
So I'll save my arguments for later.
Okay. Thank you, Representative Greer. Anyone else? Anyone else want to weigh in? All right. Then let's walk through the bill. We can take the amendments one at a time, or if everyone's comfortable with it, perhaps we would just take a motion on all of the amendments at once, unless somebody wants to divide them. So maybe we'll just see if there's a motion on all the amendments. Is there such a motion before we step through one at a time? All right, Representative Greer.
Yeah, Mr. Chairman, with respect to Mr. Kaufman's amendments, the last one regarding the threshold, regarding a derivative action, I'd like to consider that separate. The rest I'm fine with.
Okay. Anyone else kind of want to pull anything else off the consent list, so to speak? All right, then let's go with that. Let's go with the amendments as proposed by Mr. Kaufman, accepting the last one. So this is the first 1, 2, 3, 4. This is now posted on the web also, to my understanding, so you can take a look at them. It's already been gone through by Mr. Kaufman. Any discussion on the proposed amendments and proposed changes? Yep, Mr. Hopkinson.
Thank you, Mr. Chairman. I was just wondering if Mr. Kaufman would also like to include with the change on in section 17, 16, 1907, changing biannually and making it annually, if we wanted to do the same thing on page 8, line 10, and change that biannually to annually as well.
Mr. Kaufman? Seems rational. If we've got another biennial report, we'd probably want to take it to annual.
Yeah, Mr. Chairman, I would agree with that. I'm trying to find the second one. Apparently I missed it, but yes, Mr. Chairman, I'm good with that.
Okay. So we'll incorporate that into the amendment as a friendly amendment. Any further discussion? Seeing none, all those in favor of this amendment, please signify by raising your hand. Those opposed? Motion has carried. Those amendments have passed. So we are on the final amendment. Maybe I will just march through the bill right now and we'll get to that one in its place is probably the best way to do it. So I don't know that we'll have any others, but that will be on towards the end of the bill in 1716, 1908. So with that, let's walk through the bill and see if there are any amendments. Any amendments on page 1? Any amendments on page 2? Any amendments on page 3? Any amendments on page 4? Any amendments on page 5? Any amendments on page 6? Any amendments on page 7? Any amendments on page 8? Any amendments on page 9? We're now on page 10. Mr. Kaufman, want to move that amendment?
Mr. Chairman, I would move the amendment of adding the language unless otherwise agreed by the shareholders at the outset of line 6.
All right, we've got an amendment. Is there a second? I see a second from Senator Nethercott. Motion and a second. Discussion on the motion. Representative Greer, did you want to weigh in on that since you withdrew it?
Mr. Chairman, I think we've discussed this already. I mean, the 2% sets a threshold. If you started small with a corporation and you agreed, and then you brought in more shareholders later on, you know, if you started with 10 shareholders to begin with, you set that as a very high bar, and then you went out and pushed your idea, developed it, brought in more shareholders, that bar is going to be set there. And I think the 2% at least gives an accountability back to the so-called public purpose. And that's what it's looking for is an accountability back to the shareholders. So I don't think it's onerous by any stretch.
Okay, thank you, Representative Greer. Anyone else have any thoughts on this? All right. Seeing none, let's have a vote. So the motion is to insert on page 10, line 6, before any action, the language, unless otherwise agreed by the shareholders, comma. All those in favor of the motion, please raise your hand. Okay, those opposed, please raise your hand. I think I see Senator Driscoll. Okay, motion is carried on a vote of, look like about 5-2 is what we have left right there. Okay. That language has been inserted. Any other amendments on page 10? Amendments on page 11. Page 12. And finally, page 13. Any further amendments? Any amendments elsewhere in the bill? Yep, Ms. Long, go ahead.
Can I go back to that definition of public benefit? It includes the word environmental. And I just want to make sure that this group talks about the concept of providing a public benefit corporation to someone who may very well go against the industries in Wyoming that we hold near and dear, and wonder whether the word environmental in the case of Wyoming really does make sense to include there.
Thank you, Ms. Long. Let's see, you're looking at page, for those,
Page 3, I believe, yeah.
Romanet 2, the definition of public benefit. including, so it's an including list, including effects of an artistic, charitable, cultural, economic, educational, environmental, literacy, medical, religious, scientific, or technological nature. Okay. Discussion. Anyone have any thoughts? Go ahead, Mr. Coppin.
Mr. Chairman, again, I totally agree and understand the concern there. I would just point out that cuts both ways too, because it can be used for the positive, you know, ways that we in Wyoming might appreciate that being used as well. And we've seen that be the case in other states with public benefit corporations. So totally understand the reservation, but I think there's other ways to apply that too.
Thank you, Mr. Kaufman. Senator Nethercott.
I think it's a good discussion. I think the other terms that are listed there cover that anyway. So, you know, depending on the efforts, would it be educational? I mean, would it be economic? Would it be charitable? Would it be scientific or technological? I mean, I think it could be spun anyway for some group trying to do that, depending on what their purpose was. So I don't know that it gets anyone anywhere in light of kind of the broad definition of public benefit. So.
Thank you, Senator. Go ahead, Senator Dockstetter.
I appreciate the comments, but I'm not sure that I've found comfort in that, keeping that word in there. It's we know what makes it work in Wyoming. I'm a little cautious right now, Mr. Chairman.
Thank you, Mr. Majority Leader. Representative Yen.
Thank you, Mr. Chairman. I mean, I guess I always like thinking of examples of ways that, you know, certain definitions would be used. And so one example would be, for example, maybe it's a gun organization that's looking to sell hunting rifles, but they also want to sell hunting rifles that promote hunting and promote open spaces where hunters can be using their hunting rifles, right? And so that's a public benefit that, you know, may go against shareholder value, but as a public benefit corporation, they're really interested in promoting hunting across the board. And I think that would fall under environmental. I think it for me, it's hard pressed to put it in any of the other boxes. And then overall, I just really don't want to limit what people can consider as public benefits. I think once we start controlling what is or isn't a public benefit, we get into a really shady situation with a lot of areas. Thank you.
Thank you, Representative Yen. Any additional points? Go ahead, Representative Greer.
Yeah, I mean, so herein, and I didn't want to get into this. I didn't want to get into argument. Herein lies the issue. If I'm selling hunting rifles and I want to divert a certain portion of my revenue to preserving outdoor spaces and promoting hunting, I'm promoting and looking at the long-term vision of my company with a long-term goal for profitability. Again, coming back to what is the need for this bill altogether.
Thank you, Representative Greer. Ms. Long, you had your hand up again.
Yes, Mr. Chairman. Yes, my concern was exactly what Senator Dockstetter was alluding to, which is I'm not an elected official. I'm an appointee, but most of the committee members are elected officials, and I can see a headline if, you know, some adversarial group comes in and uses our own statute and uses that exemption. I can see a headline. And to Senator Nethercott's point, I had the same idea. She articulated it better than I did, which is I'm not sure the word environmental is necessary here because it probably is covered elsewhere.
Thank you, Ms. Long. Senator Nethercott.
The bill will die as a result of this conversation right now. The bell has been rung. It will never not now be rung. We have to strike it. There's no alternative unless you want the bill to die. I mean, I think it's absurd, honestly, but because it's neither necessary or unnecessary, but the bill will be dead. So I'd move to strike it as well.
I would second that.
Okay, we've got a motion and a second. I'm going to weigh in and offer an alternative, which is not to have a list. And here's the concept that concerns me, and I certainly understand everyone's possible concerns here, but one of the things that we've really tried to do as a select committee and a task force is not to tell people how to use our legislation, not to tell people what they should and shouldn't do. This strikes me as very contrary to that we're now opting to take a list and elect for the pieces of the list that we do like and remove the pieces of the list that we don't like. And I'd say that's rather antithetical to pretty much everything else we've done, where we've tried to get government out of people's business and not tell them what to do. So for us as this select committee to put forward legislation that says, all right, this time we're mad at you if you do a certain thing, is a bit challenging. And I think if we just don't have a list, we probably avoid that. If we specifically strike environmental, that might be disconcerting, and it makes a statement. It makes a statement that we're striking one word, the one that we seem to not like. And I know that everybody in Wyoming is actually an environmentalist. We care passionately about the Wyoming environment. We're the most protective of the Wyoming environment. And I want to make sure that everybody who's listening knows that. That's why we have a pristine environment. That's why we're the most beautiful state. So the idea that we would take one word out, I guess, strikes me as something that's contrary to what we've done in the past, where we know we don't need a list. We've done this many times in statute before, where we look at a list and we think, let's take out the list and let's generalize. So we have a motion on the table, certainly, and we can consider that motion. We can vote on it. But I guess I'd encourage the bringer of the motion, which I think is currently Senator Nethercott. Maybe we can just do away with the list and figure out some alternative language construction that captures the general concept of public benefit instead of a specific enumerated list of what we consider to be public benefits. Senator Nethercott, what are your thoughts on that? And Ms. Long?
I think it's too late. The bell's been rung. We have to intentionally strike it or the bill dies.
Would it not be struck if we took away the list?
The same argument will be presented now.
I think the same argument is probably presented regardless.
Logically, I think our only path forward, I've heard from 2 legislators now and the fear that this is going to be used to somehow do something for coal, that we have to now clearly make a political stand, or the bill will die. You can't unring that bell. And so, whether it is legitimate concern, it's the bell's been rung. I'm hopeful I'm wrong, but I just don't think that I am.
Thank you, Senator. Ms. Long, what are your thoughts?
To the bringer of the motion, Mr. Chairman, would she consider striking on line 8 from the beginning of the word of through the end on line 10 and replacing that with effects of a charitable nature? So it is essentially Mr. Chairman's proposal, but it actually does define charitable.
I have a feeling to get on the floor. I consider it all friendly, because I don't think it's an issue regardless, but it's just a matter of appearances that count here. So friendly.
Is charitable sufficient? Thank you, Senator Nethercott. Is charitable sufficient to accomplish kind of the objectives that we've heard? Mr. Kaufman.
Mr. Chairman, thanks. I was just going to make a suggestion on that. If that's the will of everyone here, I think rather than use charitable, why not on line 7 just end it after other than stockholders in their capacities as stockholders, and then just end it right there. So you're not essentially what you originally suggested, Mr. Chairman, just remove the list.
I think that works. Ms. Long, Senator Nethercott, thoughts?
Mr. Chairman, yes, I think that works. The only reason I suggested leaving charitable in is it does essentially define the intent of the legislation, which is that you can have really, truly a nonprofit motive. I think that's implicit, but by adding it, it just clarifies it a little bit.
Senator Nethercott, what are your thoughts?
Right. So what is the definition of a public benefit, right? So that broad definition, what does that mean? So our concepts associated with this, like Representative Greer pointed out, are with benevolent organizations or charitable trusts. We have definitions in our trust code for what a charitable trust is. How we have guidance as to this with our IRS designations for what can be considered a charitable organization under to get that tax status. So we have lots of guidance as to what qualifies and doesn't qualify as an entity for a public benefit. Now, whether or not people agree with the public's benefits purpose, like an institution of education, right, or an entity for education, well, we can come up with all kinds of scenarios that we all find fundamentally immoral that someone considers are an educational mission, and all that we think are just admirable and are doing positive things in our community. So it is 6 of one, half a dozen of the other. I think if we want to preserve the protections for this bill for what we are familiar with as a charitable one, that it's important to kind of keep that concept in mind, or to refer to or adopt the definitions associated with charitable trusts. Those are my thoughts. The concern here, and the rabbit hole we've gone down, and we'll mimic this now in the legislature, is the same conversation happened with CARES Act funding, right? We couldn't give it to nonprofits because it might go to the wrong nonprofit. And so this will happen, and I don't know how to eliminate it at this point without that fear and that specter, without just killing the bill. So whatever needs to be done to eliminate that argument, which I think will persist, has to happen.
Thank you, Senator Nethercott. Senator Dockstader, what gives you more comfort?
We're almost there. As we continue to talk, though, I have reservations, whether it's fear over what may or may not happen. I'm starting to have more reservations about this piece of legislation. I was with you on the amendments to make sure that it got where you needed to be, but I'm not sure that, if you ask for the word comfort, I'm not sure that I'm completely comfortable with this bill just yet.
Thank you, Senator. Do you have a preference as far as if we strike the list, is that better? Is it better with a partial list? Which
perhaps Mr. Chairman, perhaps that question is put to the rest of the members of the legislative body here as well.
Yeah.
Because if you feel, Mr. Chairman, that you've worked hard to get it to this point, then we need to do maybe a quick summary or a straw poll.
Okay. Thank you, Senator. What do the rest of the legislators, and how many legislators do we have left that are voting here? Let's see. We've got 2. All right. So Representative Yin, what's your preference in terms of this public benefit if we're looking for a solution? Are you comfortable with striking the list, keeping the list, selectively positioning the list?
Thank you, Mr. Chairman. Yeah, I mean, I think pursuant to my comments before on trying to adjust what is or isn't a public benefit to the group that is trying to create one of these corporations, I'd rather not tell them what is or isn't a public benefit, right? So in my preference would be strike the entire list. People know what the word public benefit is. They can make a public benefit corporation without us telling them what the public benefit is. Thank you, Mr. Chairman.
Thank you, Representative. Yeah, and I think that's a strong point. Again, typically states are neutral on the purpose of corporations, and we already have nonprofits, and we don't have a lot of say in what the nonprofits' objectives are going to be. I don't think we have a list on what can and can't be done by a nonprofit. So I guess it's probably more consistent with that. Is that accurate? I don't think we have a list like that for our state not-for-profit corporations. We don't have any statutory parameters on what can and can't be done as the purpose of those corporations, do we? Representative Greer.
Yeah, actually, our nonprofits, I think, are broken into 3 different subcategories, and they are listed out in those 3 subcategories. I haven't read them for quite some time, but yeah. So there are purposes that are set out again, and how they are structured as what type of nonprofit.
Is that, Mr. Chairman, Mr. Chairman, I'll just continue. Representative Greer, I know for tax purposes, there are some delineations, but is there more to it? Maybe we just need to get into the statutes and look at it.
Mr. Chairman, open the statutes, and there are different types of how you set up as how you categorize yourself under state law as a nonprofit, and there are lists that are associated with it. But I guess I don't care if there's a list or no list on it. My concern is that if you want something that's going to be workable, you're going to have to go in and put prohibitive language on certain types of behavior to get to, because there are environmental groups, and I can think of one where they're I can't remember the product they're selling, but they're collecting plastic out of the ocean, and they're turning around, and I don't know if they're shoes or whatever. It's a great organization. Maybe there's a profit motive there, but most of it is environmental in nature. That's a good thing. But my concern, and like you say, I'm probably the most environmentally friendly chair of minerals that we've seen in over a decade. So it isn't that. It's a matter of, I don't want to see this abused. I don't want to see a group of people get together and decide, well, wait a minute, we're going to engage in these activities under the guise, or maybe with the purpose of protecting the environment or a theory about the environment, and then yet be able to take a dividend home as a result of it. That's what has me concerned. If we can find a way to stop that from happening, then I don't care.
Thank you, Representative Greer. Senator Nethercott, back to you.
So the definition for a charitable trust under 410-406 is a charitable trust may be created for the relief of poverty, the advancement of education or religion, the promotion of health, governmental or municipal purposes, curiously, or other purposes, the achievement of which is beneficial to the community. So there's this list, but then there's this
the catch-all
provision of other purposes, the achievement of which is beneficial to the community. And it's not speculative. It is.
It is. Ms. Long.
Mr. Chairman, could I go back and ask, we have some public testimony in favor of this. I am not clear on what specifically was the reason that they wanted this as opposed to a regular corporation statute. What was it that these specific users who are interested in this felt was missing from the regular corporation statute? Are you clear on that? I'm not clear. And maybe I don't know if they're still available. We can ask them.
Let's see if I've still got them here. Yep, I see Ms. Levin, and I'm happy to, and Mr. Moeller is still there. I'm happy to invite them back in and see if they can provide a little detail and background. Ms. Levin, welcome back. What are your thoughts on that?
Thank you, Mr. Chairman, and I know Mr. Moeller is still in the waiting room as well. So by all means, he is the CEO of the company and so he may have different perspective. And I'll be honest, this is a question that I have pressed my client on as well. Why not just organize as a corporation versus desiring this for-profit public benefit corporation? And it really is the nature of the pilot project, American World Money, and what they are trying to achieve. And part of that is they are looking to take, as I talked about earlier, a disruptor technology, a new platform, and introduce it into a market. So this is the notion of a token being monetized at zero inflation. This is a really novel concept, and for part of the reason why we need the state of Wyoming to be a full partner in this, is to have other entities adopt this technology so that it can be scaled, so that it can go beyond the borders of Wyoming. Throughout this process, this pilot will utilize resources of the state. It's not going to be a burden on the state by any means, but this is, whether it's the Secretary of State's office or YDOT potentially being a verifier on the system, it is the state accepting stablecoin, the stablecoin as sales tax payment. This is where there creates a partnership with the state of Wyoming. And the thought was, well, why would Wyoming want to do this? Why would Wyoming ever even want to allow this application in the sandbox? So at the end of the day, the question is, what's in it for Wyoming? And as MShift worked through this with the pilot, the answer became, because we believe that there could be a monetary benefit back to the state. If they're a strict corporation, they could just come in and, I guess at the end of the year, give a donation to the state. But that really misses the concept that they're trying to go for here, which is they need Wyoming's partnership in this so that the project has validity. It has credibility to other governments and other states. And so it took me a while, admittedly, to get there on this concept as well. I mean, why not just organize as a corporation? But then you really do miss the benefits to the state because it's going to have to be a partnership if it's going to be successful. And I see Mr. Moeller has now turned on his camera.
Thank you, Ms. Levin. Ms. Long, did you want to speak before Mr. Moeller? Did you have any quick questions or follow-up, or should I go to Mr. Moeller?
Just real quickly, thank you, Mr. Chairman and Ms. Levin. That answered it. I don't think we need anything as nearly as broad as what's written here, because I think what you're really after is something enabling a public-private partnership. And that's actually quite different from what's written in this bill. And I think we may be able to salvage it as a result, but I'll stand down. Thank you.
Thank you, Ms. Long. Mr. Moeller, did you want to follow up?
Yeah, I think Ms. Long is right in that we are seeking a public-private partnership here, but we're looking to see what is the best entity and best structure to do so. And it came up that from my understanding of all this, the corporation structure, our sole fiduciary duties to our shareholders. Mm-hmm. Every action that we take is to the shareholders' benefit. As a public benefit corporation, we have the ability to do outside benefits and ones which do not immediately show shareholder value, but can be a true infrastructure play. And that's when we talk about a public benefit being a stable currency with zero inflation and zero deflation. That's a true public benefit, but it doesn't show immediately quarterly results to the shareholders. Zero cost of payment acceptance for merchants. We have 6 public benefits that we outlined in our letter to the steering committee earlier that we submitted as a document. I can quickly go through that, but I think that the real key is that the structure can open up our options beyond that of a typical C corp. So that's the intent.
Mr. Moeller, on that point, I think a lot of the public benefits that you offer also focus on that long time horizon as opposed to the short term, near term direct profits for the shareholders. And it seems to me, based on my understanding, that's part of the conflict. It is challenging for standard corporations to have a 20-year vision.
Generational vision.
Yeah.
So yeah. Sorry.
No, go ahead, Mr. Go ahead, Scott.
Yeah. But correct. We're not looking for quarterly by quarterly or yearly by yearly gains, but really to create a payment system and a currency structure that can last for generations.
Thank you, Mr. Mueller. Yep, go ahead, Ms. Long.
Mr. Chairman, may I propose to the bringer of the amendment, because thank you, we just, I think, got a really important clarification. We don't need something as broad as that. And I can see that there is a benefit to the citizens of Wyoming from having a corporation that specifically is designed for public-private partnerships and does not have the business judgment rule requirement to only take into account the profits to shareholders. So what I would propose is that we bring this back in our next meeting. We table this, have LSO go back and redraft the definition of public benefit to limit it to a public-private partnership in which a governmental organization within the state of Wyoming agrees to go to work on a project with a private business that benefits the citizens of Wyoming, something to that effect. And that way we narrow it. We by definition, this would only be created if there is either a prospect or a real agreement with the state of Wyoming on the table, or a governmental entity in Wyoming on the table. And that I think limits the potential that this does get abused.
Thank you, Ms. Long. I think one concern there, though, and I'd go to Mr. Kaufman, is this is just one use case. And it's my understanding that there are a number of other entities, and you know, I've had conversations with folks also that are interested in this in Wyoming specifically, that doesn't come anywhere close to the use case that was just described. And I won't really disclose that, but as we hear examples and as we have conversations, there are many different possible uses. And the reality is my understanding from Mr. Kaufman, I think 30 states, if I'm not mistaken, already have this. So we're not letting any genie out of a bottle. If a company wanted to form one of these corporations in Delaware, for example, with this list and come and beat the heck out of Wyoming, they could just do that. It's just, do we want corporations domiciled in Wyoming as part of the economic development we're working through this group? So at least they're in our jurisdiction if this legislation passes, whether it's like this without the list or whatever else. But we don't have control over public purpose or public benefit corporations. They're out there. They're doing it. They're already capable. And this is the list from Delaware, as I understand it. So we won't be preventing anything. We just won't be reaping any rewards, right? There's rewards for us here, as I see it. And we can be good to the people in our state and cultivate business like Mr. Moeller, but not just like Mr. Moeller's business. We can cultivate other businesses that were mentioned by Mr. Kaufman and others that I've had conversations about and with since we started this public benefit corporation discussion. We can crowd them out, or we can create a structure that allows them to operate in Wyoming and take advantage of some of the other things we're doing. But I really don't think we can tell them what they do. I don't know that it's really the purpose of the Wyoming state government to tell corporations what they can and can't do. I mean, we regulate them, we make sure that we limit their liability, but we can't. We try not to be overly prescriptive in this state and micromanage corporate governance. That's our strength. That's why people come here, is because we don't tell them what they should and shouldn't do any more than we have to. And the idea that you could go get a more, or I should say a less restrictive corporation in Delaware because they have a better model. I'm not enthused, I guess, about putting together a model that is more restrictive than Delaware because we have some people we don't like. Mr. Kaufman, did you want to weigh in kind of on the diversity as well? That was one of the points we're discussing.
Mr. Chairman, I think you covered it well. I don't need to circle back. Yes, to answer your question. And you know, I'm feeling a little bit badly because I probably didn't anticipate this conversation very well. We looked at a lot of states, and quite frankly, this is the exact same language that Colorado has, that Delaware has, that Texas has, that, you know, you name the state, this is the exact same definition. I do agree with your comments that just limiting this to a public-private partnership is a little too narrow. Yeah, I think you exclude a lot of really good uses for it. Again, I'm totally understanding of the concern. What I don't quite yet know how, in my own mind, how to reconcile is balancing that concern with the fact that these entities, whether or not we call it a public benefit corporation and allow these hybrid organizations, we're not, yeah, just what you said, we're not stopping any conduct. Any nonprofit could organize for any environmental purpose. Any for-profit company can organize for any environmental purpose. We're just allowing a relaxation of that business judgment rule, like Ms. Long had summarized it. And again, my sole and true real, I guess, focus on this bill is Wyoming. We're continuing to try to push and create more options for innovation to try to be a leader in the business entity space. Nevada has this, Delaware has this. It's you know, I think it's an important additional menu option for entities that are organizing here. So again, getting back to the definition, ultimately, if we have to cut out the specifics, I'm fine with that. If we leave it in, I'm fine with that. I would resist dictating no just one or two purposes. I think we cut out a lot of potential use cases.
Thank you, Mr. Coppin. Senator Nethercott, go ahead.
Just for clarity, Nevada and Delaware have this?
Mr. Coppin, go ahead.
Yeah, that's correct. Mr. Chairman, I think that Nevada's, they call there something slightly different than this, but yeah, this statute is essentially identical to Delaware's.
Thank you, Mr. Coppin. Senator Nethercott, go ahead.
Seems like a very important factor to consider. Maybe more important.
Thank you, Senator Nethercott. Well, one thing which Ms. Long suggested that we can probably, sorry, go ahead, Senator Dockstetter.
Well, just, you probably got the count that you need to move it forward. I would be in the camp that we'd be okay to table and make sure that we get it right. And then when we pass it on to corporations or whomever, we've done the groundwork for that. So I think you probably got the count that you need to move it forward. I'm gonna remain in the hesitant area at this point, Mr. Chairman.
Thank you, Senator Dockstetter. Well, realistically, I want to make sure that we have strong support for bills that come out of this committee and that we're not reticent, that we've had time to think about it. I and Chairman Lindholm and Chairman Olson and I, over the years, we haven't tried to pass a lot of legislation on a 5-4 vote. This might be one we just need to think about a little bit more and see if we can come up with some solutions. And maybe there's some language that gets us there. But I think Senator Nethercott's final point was a good one, which is if the top, we're among the top 3 in places to register your corporation. If our 2 competitors have a product and we're lacking that product, that should be a source of concern. So how can we get there, and how can we make Senator Dockstetter feel comfortable and Ms. Long feel comfortable? And I don't know if we're going to get Representative Greer comfortable, but I'd love to. So let's try. And with that, unless there's objection or without objection, I'd like to table this to the next meeting, give it some more thought, and then come back and try and bring our sharpened wits with us and see what we can do. Is there any objection to that approach? We've got a motion, but I'll just see if there's objection. If not, I'll call for a vote on it. All right, seeing no objection, let's do that. This draft is tabled. We did pass some amendments though. So what I would ask, for the sake of us working the bill in the future, is let's get the amendments that were passed integrated into another build, so that when we look at this again, we have it as it currently stands, and then we can consider work from there. All right, excellent. Well, great, good work on that. I know it's a tough topic. It's a great topic for us to be working through, and I appreciate everyone's thoughtful deliberations on it. So thanks for that discourse, everyone. That is the end of today's agenda. Co-Chairman Olson will be chairing tomorrow. Let me see, Mr. Hopkinson, do we have anything else that you need from us today?
Mr. Chairman, I don't think so. Not for today.
Excellent. Thank you very much. Ms. Long or Representative Lindholm, would you tell us a little bit maybe about what the committee and anybody who's watching at this point in time can be doing to engage with the Stampede and the Hackathon tonight and tomorrow?
Mr. Chairman, one of the really cool parts about this year's Hackathon is thanks to our great volunteers in the University of Wyoming, we're actually going 24/7. And the reason why we're doing that is because we've got a lot of folks that signed up from Europe. So while we're all tucking in tonight, and while I'm driving down to Laramie, I got a late night drive ahead of me. The entire continent of Europe, all those folks that signed up they're going to be attending the Wyoming Hackathon and listening to speakers from Europe. So that's pretty exciting. And so if you get super bored tonight and you can't fall asleep, log in to the Wyoming Hackathon and check it out, because there's going to be some great talks going on, and you might be able to pick up some ideas for future legislation.
Excellent. Thank you, Representative Lindhope. Ms. Long, final thoughts?
Yes, Mr. Chairman, everyone should go set up an avatar and go check out the virtual exhibition hall. I've never seen software like that. It's the first time I've ever seen it. It's fantastic.
Yeah, it's fun. So I hope everyone ends up with an avatar by tomorrow. We can show them off first thing in the morning. Representative Lindhope?
Yeah, thanks, Mr. Chairman. I'm kind of ornery about this. You can't have a cowboy hat for your avatar, nor cowboy boots. So we're working on a fix on that.
That is an essential fix. And honestly, I don't think
until the fix is in.
Senator Driscoll just can't bring himself to. I don't see why you can't ride a horse around there too, honestly, right? Saddle up. Okay. Any further discussion, anything for today, Select Committee? Final thoughts, Mr. Co-Chairman, go ahead.
Thank you, Mr. Chairman. I don't want to belabor our time to get to our evening, but it's been said throughout the meeting that this is a group of some heavy hitters, some influential people in the legislature, leaders inside their respective chambers. And it's also been referenced throughout this meeting that we try to move forward unanimously. And I just want to thank everyone on the committee for working so dang hard today, and tomorrow will be another day as well. But I think what has always been so powerful about this committee is the cohesive nature of it, that we don't cannibalize ourselves. When we move something forward, we're 100% together as a team. And I just have always appreciated that mentality. Appreciate everyone's hard work today, and look forward to tomorrow. Thank you, Mr. Chairman.
Thank you, Co-Chairman Olson. All right. Thanks, everyone. 8:30, call to order tomorrow morning. Enjoy your evening. Go make an avatar. Look forward to seeing you all in the morning. Take care.